DeTorres is suing his former employer, Chad Young, for unpaid wages and filing a false restraining order.
Court come to order. All rise.
Have a seat, please.
Case 2140, DeTorres versus Young.
Thank you.
You're welcome.
Mr. DeTorres, according to your complaint, you did some work for the defendant as a plumber. Didn't work out, and he terminated you, and he owes you some wages.
Yes, ma'am.
The defendant says that while your work in the beginning was okay, you were never an employee of his. You're an independent contractor. That's the way he sets it up, and he's going to explain that to me. That he paid you your wages, even though the last job that you did cost him an awful lot to repair. He was not happy with the quality of work that you did, and his counterclaim is for vandalism, something that happened with his truck, work hours lost due to your incompetence. That I'm not going to hear, sir. You know, you make a choice with an employee, and if it turns out to be something that is less than satisfactory, then you let them go. But the one who I assume suffered from what you call lack of quality work that he performed was the person that you were working for. Was that a private residence that he was doing work in?
Yes. Yeah, a bunch of private residents.
Yeah, that's the person who suffered.
Yes.
Yeah, sure. Okay, so we're going to make this as easy as possible. From what days to what days did you work?
I worked for Chad from June 13th to August 3rd.
And how much were you supposed to be paid?
For those 3 days, $840.
And that's for 3 days' work?
Yes, ma'am.
Did you say June 13th?
Yes, ma'am.
To August 3rd?
Correct.
Well, that's more than 3 days.
No, his wage he owes me from August 1st to August 3rd is what he did not pay me for.
Okay, and where did you work during those days?
Multiple residents.
Okay, do you have any sort of a call log from him?
I do. It's right here in my
Do you dispute that he worked from August 1st, 2nd, and 3rd?
Yes.
You dispute that
There was one day he actually did one of my jobs for a couple hours that day.
Doesn't matter. He has a log.
Half a day for one day.
Did you pay him for that half day?
I did not, because the job was done incorrectly multiple times.
But he did that job. Okay, now, do you have a log?
As in?
It's some sort of a work log. You have a business. You have people who are general contractors. You get a call. You don't have a payroll because you pay these people independently. Do you pay them in cash or check?
Both.
Well, how did you pay him?
Sometimes it was through a cashier's check and sometimes it was cash.
Okay, but never through a company check where you deducted Social Security.
No, because I 1099 all my employees, so they're all self-employed, so they have to do all that on their own.
I do understand. I mean, you're not the inventor of this whole system, sir, of paying in cash. Okay. Are you one of those independent contractors?
Yes, ma'am.
Stand up. How long have you been an independent contractor?
I've been contracted with Chad since July 5th.
Of what year?
This year, 2022.
Oh, so short term.
Yes, ma'am.
Does he pay you in check or cash? No, look at me.
Check it first, and then later on it became through Venmo, and then it's gone back to check now.
What kind of check?
Cashier's check.
Just a straight cashier's check with nothing taken out?
No, ma'am.
No, I go to my bank to get all that.
What?
I go to my bank to get the cashier's checks, and sometimes I Venmo him the payment too, just to pay.
I understand, but sir, you're not the first person who I know who pays their people in cash and says that you're independent contractors. You're independent contractors. I don't want to know about it. What name do you use for the cashier's checks?
My personal name.
Is this the first time you've worked for him?
Yes.
Okay, let me see what you have for August 1st, 2nd, and 3rd. Where did you work? Come on.
There were multiple residents, ma'am.
Well, you have to tell me so that he can answer. He said that you worked half a day that he didn't pay you for.
Yes, ma'am.
So let's say that's a full day. So that's $200.
Okay. See, he would email it on his work phone, and I'd follow the addresses there.
Well, then you would have it on your phone.
My short notes on this.
Just a second. Then you would have it on your phone.
It was his company phone. He took it back when he came to my house unannounced and told me that I was fired. Redeemed his truck. Got my tools out of his vehicle.
Okay, just a second. Do you have your phone?
I do. I have my personal one that I talk.
What about the phone that you took from him?
No, that one's actually broke, so it's been with Mo for the past week.
Let me see the notes that you have that you took.
Yes, ma'am.
Fascinating.
It's my shorthand, ma'am.
How do I know what dates these are for?
It was all on his phone, ma'am.
Well, that's not him to have to prove, sir.
I wasn't able to prove anything when he took his phone back. I just had that's the notes when I was employed for him as I wrote down.
It's not helpful to me.
Yes, ma'am.
So far, the only thing that he's acknowledged is that he owes you a day's wages.
Yes, ma'am.
Which is $210. The other part of your complaint is a false restraining order against you.
Yes, ma'am.
Did you file a restraining order against
did.
him? Do you have a copy of what you wrote in your restraining order?
I do.
I'd like to see it.
So what got me that restraining order is he called, made threats, and made
Was
threats.
this after you fired him?
It was.
Okay, so after you fired him, he called you.
Made threats.
Well, what did he say when he called you?
Just basically talking about I'm going to come to your house and everything.
He wanted money.
I guess, yeah.
He said, you didn't pay me.
Yeah.
Okay. You say you got a text message and voicemail from Jeremy threatening to come to my place of residence.
Yes.
Can I hear it?
Yeah. Do you want me to play it? Or do you want to look at it?
I want to look at it.
Okay.
So, Mr. Torres, did you, after he fired you and came to your residence, took your house, did you call him threatening to come to his house?
I did.
You did?
With the police. It says it on these text messages, ma'am.
Okay. I'm going to take his phone and those text messages.
There's more text. That's just the one where he said he'd send me my money.
That's the voicemail, if you want me to play it for you. Sometimes the transcription doesn't work.
Yeah.
You want me to play it?
Just.
Hey, bro. I definitely worked more than 9 hours for the last week that I worked for you. I'll be contacting my... Play with me. I'll show up at your house.
Yeah, that's a threat.
With the police.
Just a second. That's a threat.
Yes, ma'am.
Okay.
I've had more...
That's a threat.
I
Just
had
a
more incidents before that as well.
May I say something, ma'am? He accused me of going into his gated community, slashing tires on his work vehicle. I stated that I was going to come to his house after, if you read my text, I said to him, hey, bro, I think I misunderstood your text message. If I did, my bad. If not, I'll show up at your house with the police. I never went to his house. I waited to see if he'd be the big man and just send me my money like he said he would.
I listened to the message, sir.
Yes, ma'am.
The message sounded threatening.
Did you read the rest of them?
I don't care. That message sounded threatening. Where does it say here that his tires were slashed?
In my mind, somebody writing that against me, flattened tires, what else would it be?
But you have to understand that that's not what this says.
And later today,
I was financially struggling.
Well, you weren't living together at the time.
No, she would periodically come over and
yeah, but
stay at
you
my
weren't living together at the time. So how would she find out that you were in financial trouble?
Jeremy DeTorres claims his former employer, Chad Young, owes for unpaid wages and filing a false restraining order.
Okay, that message alone, if he felt threatened because you were going to come to his house, and you not only said you were going to come to his house, but you used an expletive before you did that, which sounded threatening. This may be more benign, but that phone message was sufficient for him to file for a protective order against you.
Okay, why didn't he show up at the protective custody order?
I don't answer your questions.
No,
you don't necessarily.
Absolutely.
Some people don't pursue it because once it's done, it's done.
It wasn't done.
And once it's
This
done,
is the dismissal right here. Dismissal for the
No,
injury.
I didn't show up. I understand he didn't show up, sir.
Yes, ma'am.
But I'm saying to you, I listened to your text message, and he had an absolute right to see.
Can you see where he threatened me as well with all these back and forth texts and calling each other? Because it's in the text
You're
messages.
suing him for money owed for wages and filing a false restraining order.
Okay.
You've proven that you worked an additional day for which he didn't pay you, which is $210. He has a counterclaim. Yes. He says that you vandalized the tires on his car. The rest of it, I'm not dealing with, sir. You picked this employee. You don't then sue the employee if you don't like the job that they do. You fire them and you get somebody else to do the job. But you can't sue him because did the person who you did the job for sue you?
No, because I've got a really good reputation with my customers.
Because you fixed it. Because it wasn't done right.
Yeah.
Okay.
Even up to that last day I said he worked for me, that job I had to go back to 2 weeks ago that they couldn't close on the house.
And next time you won't hire him. Yeah. Maybe other people won't either. But I want you to tell me about the tires. I want you to tell me what proof do you have that he had anything to do with your tires? When were the tires slashed, flattened?
So the police report was done Friday when he made the threats.
Friday. What date?
I got the date right here. I think it was
August 5th.
Yeah, so August 5th is when he did it.
August 5th is when
the police report was made for the threats.
For the threat, for the voicemail?
Yes.
Okay.
Okay, so it was the end of the day Friday, so court's closed for the weekend.
August 5th?
Yep. And then Monday, the 8th, I went outside to go to work. My tires were slashed in the end. At that point, I realized it was just over and done, and I need to go down and get a restraining order so people can't come onto my property.
Because you believed it was the plaintiff who was responsible. You believed you didn't have proof at the time.
Yes.
You didn't have proof.
Again, and even in my injunction, I knew all I needed was this police report to get the injunction, so I just put in my police report.
You're not talking about an injunction. You're talking about a restraining order.
Yeah, the restraining order. Yeah.
Okay.
I went to file the restraining. So in my restraining order, I put just my tires were flat. I did not put my tires were slashed at any point because I knew the police report was enough to get the restraining order.
Okay, your
tires
were
flat. Detail about my tires.
Okay, so in the police report, you have that your tires were flattened.
No, that wasn't on the police report because that didn't happen yet. The tire incident did not happen.
Okay.
That happened Friday. Monday morning, I went out in my vehicle to go to work. That's when I found them flat and slashed.
Did you file another police report?
That's when I went and filed the restraining order that day. And
okay, and in the application for a restraining order, you said?
That my tires were flat, and that was it.
Yes, okay.
I didn't mention that they were slashed.
Correct.
So I don't know how he would know my tires were slashed if I didn't mention it on my restraining order.
I don't know. That's an interesting question. Mr. DeTorres. Mr. DeTorres, stop your paper fluttering.
Okay.
What made you think that the defendant's tires were slashed rather than just the air let out of them?
Because I read this police report and it has a mark right here saying, or the file that he did.
Show me. And make a circle.
Right here, damaged property is what I read. He checked that I damaged his property because this is written against me.
Mr. DeTorres, do you understand my question, sir?
Yes, ma'am. I'm sorry. I'm nervous in the
Just a second. This has nothing to do with nerves, Mr. DeTorres.
Well, I had no sleep last night.
That has nothing to do with sleep.
As far as not being...
Just a second.
Yes, ma'am.
What I'm asking you, Mr. DeTorres, is where does it say here that his tires were slashed?
In my mind, somebody writing that against me, flattened tires, what else would it be? He lives in a gated community.
Well, that could be...
Where's the surveillance showing me that my leg injury, the way I walk, is very distinctive, okay? If he's got proof that I slashed or flattened his tires, I said slashed. It's the same thing as flattened in my mind. That's the way I think. The way I read that, that's just how it came out of my mouth.
But you have to understand that that's not what this says.
Okay? It says that I damaged his property.
He said damaged his property, and you said slashed tires.
Okay.
Okay?
Yes, ma'am.
How much were the tires?
$450.
Let me see the receipt.
I do not have a receipt because I pay cash for my tires.
Well, that's too bad. You better stop paying cash, sir. You can pay cash for tires.
Yeah.
But when you buy tires with cash and you want to sue for them, you get a receipt.
Yeah.
From the people. And if you know you're coming to court, we're not talking about things that happened 2 years ago.
Yeah.
You were coming to court today.
I went back to the tire shop and he's like, we always do cash for all your vehicles. And
well, what do you mean cash for all your vehicles? That means you get a receipt. All right, your counterclaim's dismissed because you have no proof of anything. On the complaint, sir, I'm awarding you $210, which is 1 day's pay. Thank you very much. This case is over.
This court is adjourned.
The work just wasn't up to the quality that he promised he was going to offer.
It is what it is.
That's just his nature. That's always been his nature.
The judgment is what the judgment is. She felt like I was only awarded a day's pay, and that's what she gave me.
Keep doing what I do. That's all I can do every day.
Well, Sarah Rose, that is the perfect example of you're supposed to have proof when you come to court.
Yep. Standard of proof exists for a reason.
You know, I know that when I go someplace, and sometimes I pay cash. So even if you pay cash for something,
There's some
or Venmo,
record. Venmo
you're
is a good
supposed to
record.
get a receipt in the event that you want to use whatever you bought and use that fact that you purchased something in a subsequent lawsuit.
Yeah.
It's the same thing as sending a gift. If you send somebody a gift, you keep the receipt until you know that they got the gift. Then you take it and you throw it away. It's just
It's good bookkeeping. It's good record keeping.
And he's a business guy.
Yeah,
he's a business guy. Didn't make sense to me, but clearly plaintiff was somebody who has a little trouble.
Yeah.
Case 2137, Wise versus Light. All parties, please step forward.
Caitlin Weiss is suing her ex-boyfriend, Cody Lipe, for unpaid loans.
Ms. Weiss, the defendant was a boyfriend of yours for a period of time.
Correct.
And you allege a couple of loans. One from a year and a half ago, the balance of a $200 loan, he paid you back $100.
Yes.
Quite frankly, I'm not interested in what happened a year and a half ago. What you say is, I need time to catch up.
It was a verbal conversation.
Well, what's in writing is you saying to her, I can make payments to you. But the thing that you don't have in writing is where she forgave the loan. Is that right?
Caitlin Weiss claims her ex-boyfriend, Cody Lipe, is refusing to pay back loans she gave him during their relationship.
Okay, in March of this year, you allege that you gave him money. He was still your boyfriend in March of this year, is that right?
Yes.
Is that correct?
That is correct.
And in March of this year, he had gotten a car. What kind of car did you get?
It was a Buick Regal.
What year?
A 2004, I believe.
Where did you get it from?
I got it from a private seller.
How much did you pay for it?
$850.
Needed fixing.
Yes.
And you didn't have money for parts.
I did for the first round of parts.
But you didn't for the second?
After the first ones failed, I did not.
And how much did you need for parts?
That I don't remember.
Who bought them?
Miss Weiss did.
Did you buy them on a credit card?
I believe so, yes.
And you have no idea what you paid for those parts?
I don't remember.
But that would be in March of 2022.
It would have been in April.
Did you pay for the parts by credit card?
Yes, I paid between Cash App transactions that were transferred to Mr. Lipe through Cash App, which I have present here.
I'd like to see proof of them. What do they total?
They totaled up to $920.
Does that sound about right, Mr. Lippy?
That's about right.
Okay. And tell me about the discussion that you had with her when she paid for these parts.
There was a discussion of how I was going to pay her back.
And what did you tell her?
I did agree at that time.
And then what happened?
There were then later discussions as we were still in a relationship and I was in financial troubles that she told me not to worry about it.
This $920 was a loan in April of 2022. That's what you say. It was in April, not March.
Correct.
And then you say at some point she forgave that loan.
Right.
Tell me when that happened.
Shortly after the car got back together, which would have been in May. I was financially struggling.
Well, you weren't living together at the time?
No, she would periodically come over and
yeah, but you weren't living together at the time. So how would she find out that you were in financial trouble?
I mean, we were at that state in our relationship where she knew basically my financials all the time.
When did the two of you break up?
I believe that was in June.
So shortly after you say she forgave the loan.
That is correct.
Did you ever forgive this $920 loan?
No, I did not. Brennan Black was there the day that I had confronted Cody at a car meet and had offered him a short little payment of $790 where Cody said he would do it in payments.
Just a minute. You broke up in June.
Correct.
He says that you had a conversation before that, sometime in May, where you knew he was in financial difficulty. Did you ever have that conversation with him?
No, that is incorrect. I do have statements here to prove it as well.
I'd like to see them. So then you said he owed you $970. He had been giving you some money?
Yes, he had been giving me
It says, so that puts you at $670, okay? That's what you wrote.
Correct. He had been giving me money periodically throughout the beginning of the car parts.
Okay, but it says, so that puts you At 670, okay.
Yes, there's more transactions on the Cash Apps as well.
Oh, after that?
Yes, correct. Sorry.
No, sir. What you say is I need time to catch up. There's no forgiving here unless you have some...
It was a verbal conversation.
Well, what's in writing?
Right.
What's in writing is you saying to her, I need some time to catch up. I can make payments to you. All of that is in writing. But the thing that you don't have in writing is where she gave the loan. Is that right? Yeah. $920. Judgment for the plaintiff. We're done here. Thank you.
This court is adjourned.
It is what it is.
I think it was fair. Mr. Lake did owe me money, and he got what he deserved.
Yes, she lent me the money, but at the same time, she was helping me out in a relationship, and she knew I was struggling.
He said he was going to pay me back and never followed through even after that.
There were discussions about her telling me not to worry about it.
Not to trust so much.
I'm never going to do it again.
Oh, that's going to be a contract.
She was very prepared.
Oh, she was to the point, knew exactly what she needed.
And she had all of her evidence.
Yep.
All
just the way we like it.
All lined up. It's unfortunate when a loan becomes a gift and a gift then becomes a loan when the romance is over. These writings are always so helpful, and these text messages really are making my life much easier.
And one thing that I mention a lot is with Cash App or Venmo, always state if you're paying someone money, don't just send the money, put in the subject line. They have a subject line on those for a reason, for this car part, for this tow, for this XYZ, the other. So I always, when using Venmo or Cash App or something like that, in an online transfer system, I'll send the money, and then in the transaction, you can put whatever you want in the memo line of Venmo. So housekeeping for me, I'll pay through that. Other things, I list housekeeping for, and I put the date and the hours. So I at least have a record of who I'm paying electronically.
If you buy food,
or if I give someone money for dinner for half my meal, I say for my dinner on XYZ date.
And then you can get a printout.
Organized. Exactly.
And then you can, like a bank account?
Yep.
Interesting. I didn't know that.
It just keeps it organized. So I love it when litigants come in ready to go.
Well, that's good advice for people who use Venmo.
Jennifer Paramon is suing her former friend, Cardi Moran, for television damage caused during an argument.
Court come to order. All rise.
Have a seat, everyone.
Case 2144, Paramount versus Morgan.
Thank you.
You're welcome.
Ms. Paramount, you and the defendant had been friends.
Yes.
Then, according to what I read, there was a falling out, which you will tell me about briefly. Subsequently, and without too much time having passed, you decided to conduct an intervention, a drug intervention, with the defendant.
Yes.
And it is your claim that during that drug intervention, she damaged your television set, and you want her to pay for a new TV. That's what your case is about. The defendant has a cross-complaint. She says she's missing some sort of a speaker. I don't know what that is. And for the emotional distress that she suffered as a result of this intervention. So I have a couple of questions, just preliminarily. How long have you known each other?
Over 20 years.
Friends?
Yes, best friends. Former best friends.
Former best friends. But there came a time, according to your complaint, that there was a falling out. And when was that?
That was in May of this year.
And what was the falling out about?
It was about our mutual friend and...
This gentleman?
Yes.
What about your mutual friend?
He was in the hospital, and we were all taking care of him. And she felt adamant to tell me that I need to do certain things for him. And I was letting her know that if he needs to tell me he needs my help, he can tell me.
Okay, there were several people looking after him while he was in the hospital, taking turns, is that right?
Yes.
And she was telling you things that you should be doing for him, and you said to her, if he wants me to do something, let him tell me, you don't direct me.
Correct.
Okay, tell me the next thing that happened that brings us to court today.
Well, after that, in May, I blocked her. We didn't speak.
Did you go to visit him?
Oh, yes.
Oh, yes. And did you?
Yes.
So you both did. Okay, so you blocked her in May. Then what's the next thing that happened?
Now we're in September, and this was...
And between May and September, you haven't seen her?
Haven't seen her.
Okay.
And now it's September. It's Labor Day weekend, and our friend Brandon wanted to mend our friendship back together. And it kind of did, because we've been friends for so long. We talked and kind of mended.
Okay.
Okay, so I unblocked her. And then on that Sunday, September 4th, she calls me at 7 o'clock in the morning, and I guess she still felt uneasy about, us not talking for so long, that she demanded an apology from me.
She called you early in the morning demanding an apology for what?
For basically just, I was in the wrong of not listening to her about our friend.
Okay, and then what happened?
So I refused to give her an apology. I said, we can move past it, but I'm not apologizing, which she got upset again and hung up the phone on me. And after that, she basically called a family member of mine.
Not basically.
Sorry.
You say that she placed a call to a family member.
Yes.
Okay, and you can't tell me what that family member told you because that's hearsay. You
Correct.
understand that. Okay, so she called a family member, and that was on September 4th.
Yes.
Okay, a family member called you.
The family member actually...
Did what?
Actually lives with me. So they didn't call me.
Okay, well, you can tell me the relationship.
It's just family.
Okay, family member who lives with you, and?
Yes. So she was calling that family member, asking for...
You can't tell me what any of that was about.
I'm sorry. So after the conversation with the family member told me what she said. I know, I'm not saying the conversation.
Absolutely right.
So I told Brandon what she said, and we thought at the time, let's have an intervention.
Okay, now, so without giving any credibility to any out-of-court statements, I assume by the word intervention, you had a suspicion that the defendant was using drugs or alcohol.
Yes.
Before that, before September 4th, did you have any knowledge of ongoing substance abuse with your best friend?
Yes.
Since when?
For a very long time.
Okay. Did you ever discuss the drug use with her?
Yes.
Well, you can tell me what those discussions were like. What kind of drugs were you afraid she was using?
I prefer not to say.
Well, you can't not say. That's what this is all about. You wanted to have an intervention. You didn't want to have an intervention because she was having caramel-covered popcorn. There was a controlled substance, I assume, that you were afraid she was using.
Yes.
Which was what?
Cocaine.
Have you ever seen her using cocaine?
Yes.
Did you ever use cocaine with her?
Yes.
Between May and September, had you ever used cocaine with her?
No.
So it was before that?
Yes.
His name is Brandon?
Yes.
Had Brandon ever used cocaine with the two of you?
No.
Did you ever see Brandon use cocaine?
No.
Okay. So you, who had used cocaine with her, decided to have an intervention with Brandon?
Yes.
What do you do for a living?
I'm an inbound call agent. I sell tickets.
Okay. And what does Brandon do?
He's disabled.
And who was going to be at this intervention?
It was myself, Brandon, and another mutual friend.
Mutual friend. Now, this mutual friend, whose name I will not have you state, have you ever seen that mutual friend use any sort of controlled substance? Answer the question.
Yes.
Yes. So now you have two people who've used controlled substance, one who has not, to your knowledge, doing an intervention.
Correct.
Okay, and do you know what an intervention is?
Yes.
What is it?
It's basically a meeting of the minds of having a discussion with one person about an issue that...
And who's there?
Who's there?
Yeah.
Oh, I would say trusted people that I would feel that they were...
Sarah, I want you to look up the word intervention and read me the very, very simplistic definition of an intervention.
From the Mayo Clinic, an intervention is a carefully planned process that may be done by family and friends in consultation with a doctor or professional, such as a licensed alcohol and drug counselor, or directed by an intervention professional called an interventionalist.
Okay, so what you don't have is something, I assume, this conversation occurred on September 4th.
Correct.
Was it on that same day that you decided to have an intervention?
Yes.
Okay. So let's start with the word well-planned, not as a result of a conversation that you have with somebody. And it's a well-planned event done in conjunction with very often relatives or close family who have a concern that something is out of control, some abusive behavior that's related to either alcohol or other controlled substances in conjunction with a licensed professional where everything is synchronized, but managed by a professional. Do you understand?
Yes, this was a bad plan.
If there was no plan. It was a plan made because you were annoyed. Usually people who are involved in thinking about an intervention have nothing but love in their heart for the person who needs that intervention, but they have a plan. You didn't have a plan.
Yes,
you kidnapped her into your house.
Jennifer Paramon claims her former friend, Cardi Moran, broke her television. Cardi is countersuing for emotional distress.
Now, you were annoyed at the conversation, so what you did was not really an intervention. What did you think was going to happen at the end of this intervention? What was supposed to happen to her? According to what I read, you called her, or someone called her, probably your family member called her with regard to these drugs that she wanted to purchase. Is that what happened?
Yes.
And said, I have them come to the house.
Yes.
Okay, so that's not a giant leap. You have to put that together. So she calls your family member for some cocaine. You arrange for an intervention. Your family member calls her at your request and says, come to the house. So that's what happened.
Yes.
Okay, but she was lured to your apartment.
Yes. Yes, I was.
Yes.
By whom?
By us. By her.
What do you mean by us?
They all said-
myself.
Shut up.
Myself, Brandon, and another
Well,
mutual
who
friend.
called her and said, come over?
Who called her?
Yes.
We were already going out. She was already going out with Brandon.
Just a second. She was already going out with Brandon.
Yes. And she decided to come to where I live to come pick up these drugs. Because when she found out that basically the setup was for her to get her to my house. So I told my family member to tell her that we did have it.
Oh, just a second. That's what I said. So she was lured to your house.
Yes.
Where you were going to do what with her? What happened when you got to your house?
Basically, just talk.
Not basically.
Sorry.
Not basically. You lure somebody to the house. She's come to the house now expecting, let us say, expecting to buy drugs or get drugs. She gets there and realizes that that's not going to happen, that there are other people that that's not going to happen. So tell me what happened when she walked in the house. That's what your case is.
Well, when she walked in the house, I immediately tried to give her a hug, and she was upset.
No, you immediately tried to give her a hug. What did you say?
I didn't say anything. I just opened arms, and she said, no, it's fake, backing away.
It's fake. What's
Yes.
fake?
My hug.
Okay, so she backed away.
Yes.
And
it just started off with
No. Somebody had to say something to her. Somebody had to say this is an intervention. Somebody had to say why she was there. She eventually was going to say, where are the drugs? But you have to tell me what happened.
Yes, when she walked
in, you went to give her a hug, pushed you away. Then what? Come on, this was an intervention.
Yes. So we couldn't even get to the part of this is an intervention.
How could you get to an intervention? You don't know what an intervention is.
Well, we couldn't get to a part of let's talk. She immediately said she was being set up. This is a setup with arguments back and forth.
Well, what were the arguments back and forth?
The back and forth arguments.
She said, I'm being set up. Somebody said to her, this is an intervention.
We didn't get to that part.
Well, what is the setup that she was talking about?
I don't know why she said...
Well, it was a setup.
It was a setup. It was a setup.
Yeah, so I want to know what your end game was.
The end game was to have a conversation with her so we can resolve our issues of why does she need an apology from me? We have been friends for so long. Her getting to my house, yes, we did lie and say, yes, there was drugs at my house. But she already knew from how we're all there that there was no drugs. She was upset. She was irate. She was bringing up the argument that we had earlier in the morning.
So this wasn't an intervention for drugs or alcohol?
It was an intervention for drugs and alcohol.
Oh, okay. Then I'm asking you, not what happened, what was your end game?
The end game was to have a conversation with her about how much drugs she was doing because it changed her mood. It made her angry.
Well,
it made
did you have a program for her to go to? Did you have a program to take her to? Had you spoken to a professional? Had you done anything?
No.
Okay. And when she was there, according to you, she was in your house with 3 other people?
Myself and Brandon and another mutual friend.
So with 3 other people,
yes.
So she was there with 3 other adults.
Yes.
And she was lured there under false pretenses.
Yes.
And what she did, according to you, was pick up a chair and throw it at you, or threw it at a television set, breaking the television set.
She didn't throw it at me.
What did she do?
She threw it directly at my television.
Lucky she didn't throw it at you?
I wish she would have.
That's exactly what she
did. Just a second. You're lucky. You can't do what you did. That's almost like kidnapping. If you're having a serious intervention, you have to sit down, have a working plan, what happened, have the right in your heart, have the right messaging. Your messaging was all wrong. Usually people who are involved in thinking about an intervention have nothing but love in their heart for the person who needs that intervention, and they seek professional help in order to get that person professional help. But they have a plan. You didn't have a plan.
Yes,
you kidnapped her into your house.
It was
you
bad.
Can't do that.
It was bad. It was
very bad.
Yeah.
So you fix your own television set. Your case is dismissed.
But, Your Honor, I have it all on video.
Did she break your TV?
Yes.
I'm going to look at the video. Your case is still going to be dismissed. I believe she broke your TV. Show me the video. I believe it.
And I also have
I believe that you're lucky that's all she did in order to get out of your apartment. Did she ultimately leave your apartment?
Forcefully.
Yes.
I kicked her out.
So forcefully, you tricked her into coming in, and then you kicked her out?
Yes, after breaking my property.
Okay.
No. Why would you like I squirt the dog? I cannot. I said not. Jack, are you serious?
I'm ready.
Are you serious?
Why am I being recorded?
Just a second. I don't know why you're being recorded. In any event, as I said, your case is dismissed. Fix your own TV. You have a counterclaim.
Yes.
And your counterclaim, I don't know what this speaker is. What is a speaker?
A speaker, you connect your phone to Bluetooth and you hear music on it.
Okay, so what was it doing at her house?
Shh. We were supposed to be hanging out. So I was supposed to be hanging out with Brandon and another mutual friend. I didn't know we were going to stay at Jennifer's house.
Okay, I just want to know what you brought the speaker?
Yeah, a speaker.
And you left it there?
I didn't leave it there. My things were scattered. When she was kicking me out, my things were scattered, getting kicked into the hallway.
When amateurs decide to do an intervention, any negative consequence that flows from that, you just have to accept.
But that's reason for her to break my stuff?
Absolutely. It would have been reason to her to break everything in your apartment to get out.
Jennifer Paramon has accused her former friend, Cardi Moran, of breaking her television. Cardi claims Jennifer caused emotional distress after being tricked by Jennifer.
Okay. Did you look for the speaker?
Yeah, I looked everywhere in the hallway.
Do you have her speaker?
There was never a speaker.
Did you see a speaker?
No, I didn't.
Okay, there's no speaker. Now let's talk about your emotional situation. You got to this, I can't even call it intervention. Trap. That's a good word.
There you go.
That's a good word. Thank you. And tell me what happened when you got there.
When I got there, I asked her family member, to come downstairs.
Okay. Miss Moran, you walk in the door.
Yes.
And there's no question that you were tricked and that this was a trap.
Yes.
That's what it was.
I realized that maybe 1 minute. Okay.
That's what it was. Got in there, and it was an uneasy feeling. You realized that it was a trick to get you there. It was a trap. I want you to tell me what happened when you got inside.
Jennifer starts to walk up to me, like, with her arms open, real slow motion, like, Cardi, I'm sorry. You know, we should talk about this. We're friends. In that same tone. And I'm like, yo, really? You're being fake. I don't really want this. You know, I came here to get what I wanted, and let's go. But Brandon is getting all comfortable. He is disabled, so, you know, all right, fine. He's got to get comfortable. So we start arguing, me and Jennifer, we start arguing.
About what?
About the conversation that me and her had earlier. you know, she said that I should just get over what she said initially for me getting upset.
Okay, so the initial conversation didn't have anything to do with drugs?
We never talked about drugs. When I got to the house, I never had anything to do with them. I was talking to the family member, what I came to get. But once me and her start arguing, I tell Brandon, like, all right, can we go now? Like, are we done here? Like, let's leave. I want to go.
So what happened? When you said to Brandon, let's go, I want to get out of here, what happened?
She squirts me with a water gun. She tells me, oh, I'm going to squirt you like I squirt the dogs.
Brandon, stand up. Your last name is?
Milner.
I want you to describe this water gun.
To be honest, Judge, I don't remember seeing a water gun.
It's in the video. If you listen to the video, she says it. I'm going to squirt you
Brandon,
like I squirt
before I
the
look at
dogs.
this again, you were there in the room.
Yes.
I'm going to give you one before I look at the video again. Whether you saw her squirt the water gun or not, did you see a water gun that day?
No, I didn't.
No, okay. So let's play this and let me hear what you're referring to.
I said, are you serious?
Okay, Sarah, you have a much more keen sense of hearing than I do.
I'm going to squirt you like I squirt that dog.
Okay. She's got younger ears than I do. What?
I never squirted her with the
Whether you did or not, are you telling me that
No, I
that
said
Sarah
it.
heard?
I
Okay,
said
so
it.
you did squirt.
But I
You
didn't
say
squirt
it.
her.
I'm going to squirt you like I squirt the dog. Okay, but that's not an intervention.
We
I
were
don't know.
arguing at that point. It was already past the
That's because you lured her
conversation,
there.
intervention.
Because you did the wrong thing.
Yeah, it was a horrible plan. It was horrible.
Oh, yeah, they're absolutely right. And it caused a great deal of distress. I want to know how you got out of the apartment.
I was kicked out. I was pushed out. My things were thrown into the hallway.
At what point did that happen? Is that after?
Literally 3 seconds after.
After the TV was broken.
Yes.
You were pushed out the door.
Yes.
Well, that's some really good intervention. How long were you in the house?
A total 6 minutes, maybe.
Where did you go from there?
I got picked up and went home.
Got picked up by
2
whom?
hours later by my sister-in-law.
Don't make anything up.
No.
Who picked you up?
My sister-in-law.
Okay.
And my daughter and her boyfriend.
In that 2-hour period,
Yes.
you must have waited somewhere for them.
Yes, I waited in her hallway.
Okay, so you waited. When they came to pick you up, was there any further conversation with her or Brandon? They just picked you up.
Well, between those 2 hours, there was conversations between my daughter and Brandon, my daughter and Jennifer. Everyone was talking.
Well, where was your daughter?
She was home.
So it was on the phone that they were talking?
Yes, and she was pleading with them to give me my stuff back so I could just leave.
The cross complaint, or the countersuit, is seeking $1,800. It's seeking $1,800 not only for the emotional distress that was caused to the defendant, but also for a speaker. They don't have a speaker. How much was the speaker so that I can deduct that?
It was $129.
Okay, so we're really talking about $1,700. Okay, and that's the amount that you want for your emotional distress.
Yes, Your Honor.
For that 6 minutes. I don't blame you. I think it's worth at least that. I think that when amateurs decide for all the wrong reasons to do an intervention, any negative consequence that flows from that, you just have to accept.
But that's reason for her to break my stuff?
Absolutely. It would have been reason to her to break everything in your apartment to get out. Absolutely. You are holding her there. Yes, just a second. You brought her there under false pretenses. That's what you did. And you had somebody else there as well. And according to you, you wrote it was an intervention. But it wasn't an intervention. It was whether you wanted to.
For a 20-year relationship, intervention may be a wrong word.
Well, it was a very, very wrong word, and you don't trick somebody to come to your house with something else in mind, even if it's to buy drugs. So I'm awarding you $1,700 on the counterclaim for your emotional distress. Your claim for the broken TV is dismissed. We're done.
This court is adjourned.
I have no thoughts.
I'm happy with her decision, but it's bittersweet because these are my friends.
Just have a conversation about certain situations we were having.
Her intention, I don't think it was to make me stop doing what they all do anyway.
I didn't keep her, that's the thing. She walked in freely, walked out.
That's the betrayal.
Yeah, this is over.
It's just time to go separate ways. You know, I lived and I learned. Those are the people that I grew up with. You know, those turn-up days are over anyway, so.
I think this whole situation was a perfect example of what my dad calls lack of two-step thinking.
Okay.
So we can already agree the intentions were not great. They were just maybe potentially rekindling a friendship, and that's not exactly the person you want leading your intervention, if that's what they wanted to call it. And also, what was your plan? If it went the way that the plaintiff at least claims she was intending it, was to get her friend help, say that the defendant broke down and cried and admitted to having a problem and really wanting help. Where was the help? There was no help.
That's true.
So I agreed with you that the plaintiff deserved any amount of damage that happened from having such a lack of a plan.
It was a lack of a plan. She lured her there.
Yeah, I mean, just a messed up situation all in all. And you really have to be coming from the right place to do something like that. And I think neither of them were even close to that sort of healthy place.
Neither the witness.
Previously on Judy Justice.
We start arguing at this point, like we're both yelling at each other, it's getting heated. She then tells me that she's going to have some dudes come and beat me up. Gallo, out of nowhere, comes from a corner and tries to swing at me. She then lets these men inside the house. They're banging on my door, talk about bring your outside. All this mess, I immediately got everything that I could, and I booked a hotel at the Westin.
Claim is that during the time that you were in the hotel, there was damage done to the property.
Right.
This is the way you found it.
Yes.
Can you explain these photographs to me?
I can't explain the photographs. I didn't do it.
This is vandalism. Somebody took powder and liquid and broke mirrors. And quite frankly, I don't know this gentleman well, but he does not appear to be psychotic. Do you have any other proof that he caused this serious vandalism of his own house?
I do not have proof that he caused it, but I do have proof I was not there, and
I don't care whether you were not there or not. So I have to decide if it was a stranger, the plaintiff, or this side, maybe not you, but someone acting on your behalf.
And now, the conclusion. Carlos Guillen claims his former roommate, Nigel Pine, and her boyfriend, Gallo Jume, vandalized his property. Nigel is countersuing, claiming Carlos had her falsely arrested.
Okay, so if there is no other proof, what?
May I interject, please?
Sure.
Over the situation that he's trying to say that happened on the 27th, that even led to the whole craziness that we see in the photos over the vandalism, is a lie. And in his police reports, I don't know if he'll show you the police report or anything that happened, details and dictates everything of what the situation is.
May I see the police report?
He came to
Do
her.
you have the police report?
She has.
I was not able to get the police report because I am listed as a suspect. I'm not a victim, so they wouldn't give it to me. But if I may interject, because you're going to...
I'm reading something.
You're going to need more information to understand.
These are all pictures of your room.
Yes, ma'am.
Ransacked.
Yeah, my room and then the living room as well.
The living room sofa, but this is your room.
That's my room.
This is your bed. Yes, you wanted to say something.
Yes, so Your Honor, as far as the room goes, I just want to add that there were multiple people living there. I moved in June while him and his family member went through an eviction process in April. So multiple people found out that we had to leave randomly. And so I wholeheartedly believe that someone else did this.
That's not true.
I can't
Don't interrupt her.
Sorry.
show you proof that he did it. To be honest with you, I don't know who did it, but I know I didn't, and I know he was with me as well. And
what about your brother? Was he with you?
My brother is...
I'm just asking you.
No.
What about your father? Was your father with you?
No.
Okay.
My father...
Just a second. I just asking you. The plaintiff said that there were 6 other people that came to the door, other than your brother. Who else came to the door?
No one.
Okay, so your brother just came alone?
Yes, Your Honor.
And when he came, was the plaintiff still there?
Yes, Your Honor.
Okay. And he stayed when the plaintiff left?
No, Your Honor.
Okay. Well, go through the timeline with me. He came because you called your father called your brother because you were having difficulty, okay? And your father sent your brother right over and said, you better get over there. She's having difficulty with this guy. You go over there and straighten it out, whatever it is. How old is your brother?
My brother is 22.
22.
Mm-hmm.
Big, little?
He's slightly taller than me. He is more built, maybe like the size of the bailiff, a little shorter.
Just a second. Okay, good. So when he came over, and you let him in?
No, he did not come in.
He did not come into the house at all?
Not until Carlos opened up the door.
Just a second, well, I'm asking you. He came into the house. Carlos opened up the door. Mm-hmm. Did your brother come into the house then?
Into the house, no.
Did he just stay in the front?
Yes, Your Honor. He stayed in the doorway.
Okay. There came a time that day that the plaintiff left the property. He went to stay at a hotel. He did not come home on that night of the 27th.
Yes, Your Honor.
That's clear. When he left, where was your brother?
I have no idea.
And I don't believe that your brother left you alone there before he left.
So
you have to understand, if your father sent your brother to be there to
Your Honor,
protect his sister from him...
There are things missing, and if you would allow me, I would like to tell you what actually happened that day, at least from my perspective, because it was never he left immediately. What happened was he came into my door at 7 o'clock in the morning, banging on my door, which I have a photo of the hole he put in my door, threatening me, asking me if Gallo was inside of the room, and he wanted to fight me and Gallo because Gallo told him to leave us alone. And he sent threatening texts to Gallo saying, I'm gonna beat you up and we could fade and bucko this, bucko that, all this. And he's like, you know, like that. I called Gallo like, hey, Carlos is banging on my door looking for you. He's like, yeah, I know. I saw the messages. I'm on my way. And I'm like, okay. So we're arguing. He's at my door. I call my dad because I'm like, I don't know what's gonna happen. And he's like, oh, he gets upset. So he calls my brother. My brother, he happens to work in the West Side as a security guard. And he's like, well, Pops just called me. Do you need me to stop by?
I understand all that.
Exactly.
Go ahead.
So after he gets there, sees Carlos outside, I go downstairs after Carlos goes to his room, and I talk with my brother. And he's like, well, what's going on? And he's like, why he don't want to come outside? And yes, my brother was very upset because I told him, like, you know, this man was threatening me.
That's hearsay.
Yes.
That's hearsay.
So,
okay, let's understand something. This all came about, pay attention. This all came about because the two of you work in the same place. You had been living in the apartment for 3 months, and there had been no other police incidents up until this time. For 3 months. This incident, according to what I'm putting together, happened because after your boyfriend Gallo left and had a conversation with him about arguments that you had had with him, which you're not going to tell me about now because you're going to tell me that never happened. That's not something people make up. And he said he got into your business. That's what you felt. He got into your business.
No,
and
Your Honor,
just
that's
a
not what I
second.
felt.
Just a second. And then you were talking about it to people where you both work. You acknowledged that you were talking to people about it where you both work.
Yes, Your Honor.
He got angry that you were bringing stuff that happened at home to work, and he came to confront you. That's...
No, Your Honor, that's not. I have text.
That's exactly. Just a second. That's exactly what happened. That is exactly what happened.
He came to my door because of these text messages. These text messages are time dated. He came to my door because he messaged him.
While I was at work over a dispute. It might have been about whatever the coworker said. He basically came to her door in his boxers.
No, listen to me. I'm making it simple, Gallo.
And so he texts Gallo, say, hey, G, I'm not fucking with her no more because she has an attitude problem. Gallo told the plaintiff, I see what you want, like you're a hater. And Carlos responded and basically said, I want to fade, I want to fight. And that is the morning he came banging to my door, which caused me to call my dad.
Defendant Nigel Pine has accused her former roommate, Carlos Guillen, of getting her falsely arrested. Carlos claims Nigel vandalized his property when he was gone.
It started because you told your girlfriend about the brief conversation you had with him after an argument. You say no, you're not going to say yes. Now you're still together, right?
We're together, but
still
that's
together.
Not the issue of
okay,
why we're here where we're at.
And she got annoyed because the person that she's renting a room from, who she works with, is telling her boyfriend, listen, you don't have to stand for that. You know, you got your whole life ahead of you. You know, move on with it.
Your Honor, that is not what happened.
Oh, really?
I'm begging you to listen to me.
Just show me.
He's not that type of person.
Gallo,
if
I may. So, what I have in my hand is a message where he came...
Just show me. Don't read it.
May I? So if you see it the first on the top page at the bottom, that message was birthed from him coming to my door while I was doing my hair and telling me to send him. He wanted to talk to. He had his boxers on. He wanted to talk to me.
Just a second. What is this supposed to tell me?
I'm telling you right now, and then you read the message. I'm going to tell you the story that led him to say that last message, because what happened was I'm sitting in my bed doing my hair, minding my business. He walks to my door with just his boxers on speakerphone with a female. He's like standing there in the doorway, and I look, and I'm like, what's up? I'm like, what's up? I'm like, all right, well, let me know when you're ready. And I closed the door in his face. Like, I closed it because he has his boxers on. He's standing there, and I'm minding my business doing my hair. So I basically tell him, let me know when you are ready to talk, because you're standing here in your boxers like I'm good. And so when I open the door after, he's like, all right, I'm ready to talk. He basically like, I'm not with your attitude.
Just a minute.
Slam the door in my face and all this other stuff. And so he texts Gallo that message you see there, say, hey, G, I'm not with her no more because she has an attitude problem. But I was upset because he was standing at my door in just his underwear. And so he texts him that. And then the next series of messages you'll see, Gallo told the plaintiff that basically you need to mind your business, and I see what you want, like you're a hater. And Carlos responded and basically said, I want to fade. I want to fight. And you'll see those in the messages. He said, I want to fight. G, ain't got nothing to talk about. You're weird. All this buffoonery, the threats.
I don't have dates on this. Is this the 27th of August?
Yes, that is that morning.
The 27th of August.
That is that morning.
That's that morning.
And that is the morning he came banging to my door, which caused me to call my dad. He came to my door looking for Gallo to fight him.
I'm done with this case. I'm done. I'm done. You have a counterclaim.
Yes, Your Honor.
I'm going to hear your counterclaim. Right now, this is a disaster, including the cutting up of the couch. There's no question that all of those items are worth $10,000. Now we're going to hear your counterclaim. And your counterclaim is that you were arrested falsely, tampering with tires, lost wages, and cyberbullying. I've read the messages. They're nasty. People say nasty things. That's not cyberbullying.
No, there are more.
Well, I want you to circle the ones that you say was cyberbullying. Cyberbullying. Give her a pen, please, Kevin.
Thank you.
Don't give me anything that's not circled. Are you still living at the house, sir?
I have keys to the house, but
that's
I'm
not what I asked you. Are you still living there?
No, ma'am.
Okay. I'm reading through these text messages. You said you can't fight stupid with stupid. Instead, I chose to remove my items and kick back in a 5-star hotel until my new place is ready.
Yes.
So you were moving into a new place.
I was, Your Honor, yeah.
When did your lease start?
It would have started on September 10th, Your Honor.
Is the place furnished?
Not fully, Your Honor. No, I did get a new bed. That's about it, as far as furniture and a dresser and, like, just the stuff I was able to save that she damaged at the home.
Just a second. Did you take the sofa?
No, I did not take the sofa.
Did you buy a new sofa?
No. I have a studio, so it can't fit.
So it doesn't fit?
No.
Anyway. So you were moving. So you purchased a new bed. Do you have the bill for the new bed?
Not on me, Your Honor, but it's
Well, that's
same.
what, you know.
Yeah.
She may have destroyed all this stuff, but if you weren't taking the stuff with you anyway because you have a studio apartment.
Right. Yes, ma'am.
You had to buy a new bed. I could understand you not having this bed.
Right.
Okay. Well, first of all, it's not cyberbullying, any of this. It's nasty, but it's not cyberbullying. He does say in these emails, he came crying to me at 7 in the morning talking about how she beats him, calls him names, and says she wants him out of her life. I simply told bro not to worry about himself, to move on, just like any person with common sense would. This trick decides to go around my job and tell people I'm dirty. I don't pay my bills, and I'm trying to blank her man. All right, so I've just stricken cyberbullying. You have bill for the bed, sir. And if you don't, I'm going to allow you to tell me what you spent for it, because so far the $10,000 is coming down. How much was the bed?
$5,000, Your Honor.
Show me.
I didn't bring the receipt for the new bed. It was just for that bed that she damaged. Because I have a Kelly King now. She damaged my queen. So I have the comp for the queen bed that it was.
Well, I'd like to see that bed, which I see here. So you're going to show me a comp to this bed.
Yeah, sure.
Okay, let's move to false arrest. Well, you were arrested in part for vandalism, is that correct?
No, Your Honor.
Well, that's what the police report says.
Well, honestly, I haven't been able to see the police report, but I know that based on what officer gave me, I was arrested for theft.
Okay, what I'm telling you was the police report says he reported that the suspect vandalized property, also that property was missing from his bedroom, but he is clearly accusing you of vandalism. And the report says a report of theft, but the officer clearly arrested you probably for both charges, because the police report says vandalism, and I find that was a legitimate arrest.
No, Your Honor.
That's what I find.
Okay. And I go to my car to go to work, and all 4 of my tires were flat and bolts were missing.
So were the tires flattened and slashed?
To be honest, I don't know, but they said there were holes in it and they weren't patchable.
I don't believe in serendipity and coincidence. This is far too coincidental.
Defendant Nigel Pine has accused her former roommate, Carlos Guillen, of getting her falsely arrested. Carlos claims Nigel vandalized his property when he was gone.
Did you find that for me?
Yes, I have an image of it, Your Honor, so sorry. Here you go. That's the mattress that she damaged.
So you had a queen and you bought a split king, is that what you're telling me?
Yes, I bought a Cow King, yes.
Okay, so that was $3,000.
Yeah.
Okay. And you left this bed here, or what did you do with it?
I had some people clean it, so.
You had what people clean it?
I called my maintenance people who helps out with the house and stuff, and he got some of his crew, and they cleaned out and cleared out the whole apartment, Your Honor.
Cleaned out the whole apartment?
Yes.
What did they do with the bed?
I believe they trashed it, Your Honor. I'm not sure.
You don't know. Do you have a bill from them?
From them, no, Your Honor.
You don't have anything. I mean, what is it that you have? You don't have a bill for a new bed.
Yeah.
You have a bed that you say is comparable. You don't have a bill from the people who cleaned out the apartment, because I assume somebody had to clean this apartment.
Right.
If you were moving out.
Right.
Well, right. I know I'm right. All right. I'm getting more disgusted with this case at every turn. Strike $10,000. Tell me about your tires. When did you find your tires
So the
tampered
27th,
with?
after the police left, after we agreed to peace, I went upstairs to go to sleep.
He was still in the house?
Yes, Your Honor.
On the 27th?
And when I woke up, I was getting ready to go to work. I noticed the electricity was off, which in those papers I gave you, he stated he turned off the electricity.
Yes.
Electricity was off. Everything was gone as well. Like, not everything, but like weird random things, like the microwave was gone. It was like a PS4 and like some like game setup thing that was gone.
Okay.
Like all the valuables were gone.
So he had taken some of his stuff out because he was moving.
Mm-hmm.
Well, he moved. Are you telling me he didn't move? Didn't move?
Not yet. No.
Oh, he's still there?
He was still there. But he
I mean, today, now. Is he there now?
Oh, no, Your Honor. But he was still there. Like, his things were still there.
Some of his things were still there, but he took some things with him.
He took.
When he left on the 27th.
With the things he claimed was valuable. Anyway, so I go downstairs and I go to my car to go to work because, like I said, I didn't think this would go any further, to be honest with you. And all 4 of my tires were flat and bolts were missing out of my tires.
You have photographs of that?
Yes, Your Honor.
I'd like to take a look at it.
Are these repeats? Oh, this is one with the timestamp. Thank you.
And he was not there?
No, Your Honor.
So were the tires flattened and slashed, or were they?
To be honest, I don't know, but they said there were holes in it and they weren't patchable at all.
So there were holes in all
Yes,
4?
Your Honor.
Do you have the bills for 4 new tires?
No. I paid cash. I should have.
That doesn't mean whether you paid cash or not. It means we're not talking about.
We're not talking about. But I do have a receipt for the tow.
The tow I will take.
Which I ended up having. So we used Gallows AAA, and it was his 4th toe, so he wasn't going to be able to get another one after that. So
I just
paying him for the extra toe, which is $90. And then I bought 4 new tires.
Well, I can't help you with the 4 new tires because what you come here for is to prove to me any element of your claim. Right now, the plaintiff has not proven all the elements to his claim for $10,000. I believe he had to buy a new bed because that bed was destroyed, and I've already indicated who I believe is responsible for that. I do believe that he or somebody acting at his bequest, because I don't believe in serendipity and coincidence. This is far too coincidental. The damage to the home was far too coincidental to your argument with him, and the damage to your car is far too coincidental for me to be comfortable with. So I would, if you had a receipt, and we're not talking about years ago, we're talking about recently that you say you had to buy 4 new tires. Well, whether you pay cash or check for tires, you can get a receipt. And if you know you're coming to court, you're supposed to get a receipt. The same thing I'm telling you.
I didn't know I was going to court. I thought it was all over with, to be honest.
Very, very good. Judgment for the plaintiff on the complaint. My original order was for $3,000. From that, I'm reducing it by $90, so it's $29.10. Judgment for the plaintiff. That disposes of the counterclaim. Thank you very much. We're finished here.
This court is adjourned.
He never lived there. We don't argue like that.
We never argued. It never was a problem. He's basically... His issue was with her.
She's a hater, to keep it real with you. She assumed that I was trying to sleep with her man when I was just giving him evidence, so.
We have DMs, messages. He came to me talking about her, and I addressed him. That's my girlfriend.
Yeah, I mean, there's text messages of him thanking me. So it's kind of weird how that played about, but I don't know.
He's tired of her, he's annoyed, and I'm like, that's not nothing that you should be telling me. You guys don't need to talk. She stays on the 3rd floor, you're at the bottom. Leave her alone.
I definitely did respond, letting him know that, you know, if you're gonna go around saying that I'm trying to sleep with you and spread all these lies, then we can definitely have a conversation face to face. I did say that, yeah.
But he's already been treating her like this from the jump. And that's why I messaged him to basically leave her alone.
They definitely damaged his house. I've seen it for myself, so it's unfortunate how it ended, but we know the truth.
Honestly, I don't
want to hear from him ever again.
I think you were right that there was far too many scenarios that lined up a little too perfectly around the same argument for it to be somebody else.
Some other dude did it. You know, I'm sorry that the plaintiff didn't tell me he moved and was, in fact, moving within a couple of days into a studio apartment. That would have been interesting information to have right from the get-go. I don't know why I didn't have it. It just would have gone to the extent of damages. I mean, if he had to buy a new sofa, and certainly from the vandalism, that sofa he needed, but he didn't need a new sofa. He had a studio apartment. That doesn't give somebody the right to vandalize your property and to break things.
But the law is allowed to use common sense in determining damages, and I think your final ruling on canceling out the defendant's countersuit with the plaintiff's too large of an ask for damages was the right call.
You think so?
I think so.
You know.
I wish he had the receipt for tires. You could put 2 and 2 together that, okay, clearly...
Oh, I saw the photographs. The tires were clearly flattened, but you don't know if they were flattened as a result of somebody taking the plugs off them and just letting the air go out of them.
And without a receipt or without a mechanic's note.
Really don't know. And this all happened 2 months ago, so she should have the bills. Anyway, you tried to use common sense, and when the physical evidence isn't there of who done it, you sort of try to piece together a scenario that makes sense. Unfortunately, now you have some text messages and you have emails that assist in that. Not everything is a picture. More and more so, at least in the criminal system, it's becoming a picture because everybody has cameras all the time and there's cameras all over the place. But in these civil actions, very often there are.
His former friend, Lawrence Sr., for money he gave Lawrence to run a boys' basketball team.
Court come to order. All rise.
Have a seat, everyone.
Hello, Judge. Case 2167, Gabriel versus Senior.
Thank you.
You're welcome.
Mr. Gabriel, it's always exciting for me when I find a case that I can't relate to based upon my own personal experience. And this has to do with sports.
Yes.
And those people who know me know that I'm really a non-functioning American when it comes to sports. I understand baseball, but nothing else. However, I have a little bit of experience with people. So you have a son, that would be you. Could you stand up for a moment? Who's tall, now you can sit down, and who likes to play basketball.
Yes, Your Honor.
And he's been playing basketball for a long time. Well, most sports stopped at the start of the pandemic. And he was playing for a team.
Yes, Your Honor.
I know that I'm going to get fuzzy on this eventually. So far, I'm holding up okay. So he was playing for the team. The team closed down, as did most other things. And the pandemic is sort of winding down, and sports are coming back. And you wanted your son to play basketball because this is your senior year in high school?
No, I'm a freshman in college, Your Honor.
Last year, so this happened last year?
Yes, I was a senior.
So this happened last year when he was a senior in high school, and you wanted him to play because he enjoyed it and because you thought somebody would find him? A scout?
Mostly the enjoyment, but there's always a chance for the scout.
Okay, and you know, you're his father, and fathers always think that their sons are uber talented and maybe can be one of those quiet self-starters who turns out to be the hero on the basketball court. I have a grandson who plays baseball, and he plays baseball pretty well. Plays in college. His father follows him around from one game to another like it was a full-time job.
I can relate to that.
It is.
Well, your son wanted to play. There was no team. The defendant was a basketball coach who you knew.
Yes, Your Honor.
Whose team was also the teams that he coached were also defunct because of COVID. So far, correct, Mr. Senior?
Yes, ma'am.
So at some point, you approached him and said, I'd love to start up this team again because I would like my son to play ball. He wants to play ball, and nobody else is doing it that I know of. What would it take to restart a team that could be part of a league or play other teams? You know.
Yeah, you're right.
You know.
Yeah.
Is that close?
Yeah.
You're close.
You're close.
Yes.
Close enough.
Yeah.
Yes.
Perfect. So you talked about an amount, and Mr. Senior said, I can start the team up for $8,500.
Yes, ma'am.
You, who wanted desperately for your son to play ball his senior year, said, I'm going to give you the money. You gave him $8,500. So far, correct?
$8,200.
It's $8,500, Your Honor. I have the check right here if you'd like it.
Okay. If you have the check, cash it. So it's $8,500. The team only played one game or one tournament?
No, it was actually four tournaments in total for that season that we played.
And how many are you supposed to play?
We had planned on 6 in total. 1 would be out of state or far away.
No. How many games were supposed to be played by your son's team being coached by the defendant?
So a tournament could have 3 games. And that takes over the course of a weekend, a Saturday and a Sunday.
So
a tournament could be 3 games.
A tournament is 3 games.
Could be 4 as well if you're successful.
Okay, so you were supposed to have 4 tournaments?
We were supposed to have 6 tournaments, and we did have 4.
Okay, so you played most of the games?
Yes.
And then the team was disbanded?
Yes.
For whatever reason, may or may not be relevant. So how much money do you want back? You're suing him for $4,800.
Right.
Well, you know, math is my second non-strong suit.
Yep.
But if you paid him $85 and you played 2/3 or 3/4 of the games that you were supposed to play, why do you think you would be entitled to $4,800 back?
Because I also fronted the money for the uniforms.
Well, that was spent.
And the graphics.
Well, that was
in
spent.
addition to the $8,500.
I understand that, but that was all spent. The uniforms, the players got. Right? And they kept them?
The players kept some, and the defendant has the rest of them.
Okay. Do you want them back?
I do not.
Well, he'll give them to you back if you want them, because he's not using them.
How do I know that? This is his team, his organization. It's a non-for-profit company.
Okay, let's deal with it slowly. We're dealing with the math first. Do you have, Mr. Senior, do you have any of the uniforms?
No, ma'am. I never collected the uniforms.
Did you
sole
have?
Possession.
What?
Well, he had sole possession of the uniforms.
So you don't have any uniforms?
No, he's the one that handed them out.
Okay. Did any of the players give them back to you?
No, none of them gave.
So you don't have any uniforms? He doesn't have any uniforms?
Okay. But, Your Honor, it didn't cost $85 to run the team, that's my...
Just a second. Not what we're talking about, sir. Your $8,500 went to have 6 tournaments. You had 4 tournaments, right?
Yes.
Whether or not you get your money back is a whole other thing. But the uniforms were purchased. That you don't get back. The advertising graphics were done. That you don't get back.
But that's
Whether
not
it's
my
for
name
4
on
or
it.
6.
That was his team's name on it.
Doesn't matter. What difference does it make?
Majority did not pay.
Do you have anything that requires that they pay in a contract?
That would be Coach Larry that he does, and he passed out those to the kids.
No, he didn't put in $8,500. You did.
Jason Gabriel claims his former friend, Lawrence Sr. owes him money after they started a boys' basketball team.
Now, can you tell me why the tournaments were cut short, sir?
There was a number of reasons, Your Honor. One of them was right from the start, both me and my other son tried to discourage Mr. Giamni about forming a team of that age group.
Okay. I don't want to get back into that, sir. You took his money. You played 4 out of the 6 tournaments. How much were you paid to coach out of this $8,500?
I wasn't paid anything.
Did you?
It's more of an administrative cost.
What administrative costs?
Scheduling tournaments, gyms, gas, transporting kids that didn't have rides. More than half the team was not supported by their family. At least one kid was
Well,
homeless.
was there an accounting that you asked for, sir?
Yes, that was my initial response to Coach Larry. Was yes, he told me $8,500 to start the team.
No, I'm asking you an
And then I
accounting at the
asked him-
end of the day.
I asked him where the money went. Like, could he account for $8,500 in addition to $1,600 that other kids paid to play? That's how I was going to get my money back. It wasn't just, I'm going to give you the money and you go do with it what you want. He told me it was $8,500 to start the team, and I would get my money back.
Oh, from what source?
The kids pay to join the team.
Okay. How many people were on the team?
We had as many as 14, maybe 16 come through.
To tryouts. They didn't play. I'm sorry. How you doing, Your Honor?
How am I doing? I've been better. You're his son?
Yeah, I actually run the program with him. Yes.
Okay, good. So how many young men were playing basketball?
On the team that you're talking about that's in question, I believe there was as many as 10 to 12 that actually came. The numbers vary because we're talking about 18-year-old children that come and go as they please. They don't really want to be that.
18-year-olds are maybe children to their parents. They're not 18-year-old children.
When it comes to this, then
well,
the responsibility part, yeah. I don't know. I'm old, I guess. They're children to me still. Sorry.
What I want to know is, did you have a contract with him, a written contract?
I did not.
You just said, here's your $8,500 and I'll get my money back when the kids sign up and pay their dues. How much do they pay each to join the team?
Coach Larry set that number at $600 per player.
Is that correct?
Yes, ma'am.
Can we tell you where that number comes from? Over the years, because we've been doing this for over 20 years, the average cost to run a team for a full season, we averaged it out to be about $600 per kid, because on a 10 to 12 man roster, 10 being the least you should have.
How does he make money?
We don't make money, I'm sorry. We don't make any money.
So you don't make any money, you just do this for the love of the sport?
He grew up in a basketball family, he's played basketball all his life. I've been in a sports family, my brother has, and we just love sports.
So this is not a money-making operation?
Not at all. We probably put in more money than we've made or put out in the program. I'm sorry.
Go ahead, sir.
Your Honor, I coach high school football. Actually, his son goes to the school I coach. So I was aware of him, and I also coach baseball. So I just don't, you're not going to make any money coaching youth sports if that's what everybody's saying.
Well, I'm just asking you.
No, I know that.
I'm just asking you, because there is a suggestion here that some of that money was to pay you as coach. And I just want to know whether that is in fact correct, whether any of this $8,500 went to you.
Not directly, no. I'm talking about gas.
Indirectly to pay for gas and pick up
maybe a
that.
car repair. I only had one car at the time.
Okay.
So
Mr.
me and
Gabriel,
my wife were retired.
Mr. Gabriel, can you tell me if you have, since you have no written contract,
yes.
You have no written contract requiring anything. You were supposed to start up a basketball team, which he did. I assume you played, is that right?
Yes, Your Honor.
And you played in 4 out of 6 tournaments. Stand up next to your dad. Did you play successfully?
I only played 3 out of the 4 tournaments.
That's reasonable.
But we were
Is
successful.
that normal? That members, I don't even know how many people are on the basketball court at a time.
5 at a time.
What?
5 at each team at a time, so 10
5
total. Yes.
Well, if you had 10 to 12 kids, you were what? What? 11? I don't know.
I tried to expose it to you before this case. I tried to put it on TV. I played the Lakers.
So if I get back up to
Clippers.
2019, we met Coach Larry in 2019. I didn't just pick him out of the blue now.
I didn't suggest that you picked him out of the
So
blue.
my son
Mr.
played for
Gabriel.
him in the past.
Mr. Gabriel, you don't look like the man that would give some stranger $8,500 to start up a team, not knowing him.
Correct.
Okay, I accept that. I just don't understand that as a. Are you a business person?
I am.
What kind of business are you in?
I'm a contractor.
Well, if you're a contractor,
Yes.
that I know. You have contracts.
Absolutely.
You're a contractor has contracts, and the contract that you do, you build homes or you build.
I remodel homes, yes.
Okay, so the contracts that you do lay out with specificity what you're going to do, what the materials cost are, what the VIG is on it, within a certain amount of play. But it lays out everything that you're going to do. You're turning over $8,500 to the defendant, and there is nothing in there that suggests that with any specificity what he has to do to comply. He had to start a team, which he did, right? Had to start a team, which he did, where your son played.
Yes.
Which he did. There were supposedly 6 tournaments, out of which 4 were successfully played, and your son played in 3 of them, right?
Yes, Your Honor.
So you should have been happy. Somebody got a chance to see him. Did anybody give you a basketball scholarship?
I do play Division III basketball in Brooklyn.
Good for you. There you go. Did somebody find you at one of these games?
No.
How were you recruited?
I did multiple showcases, and I won in Connecticut in particular.
He's a good player, Your Honor.
He's a good player.
And so I was found through showcases that I did by my own.
Okay. But you played, and that was good practice. It was good.
Yes.
I don't know why it was disbanded after 4 tournaments. Do you?
Do
you?
Yes. There was multiple players who did not want to play anymore because they were verbally abused by the coach, and they just were fed up. And then there was other players that were let play for free, and people just thought that was unfair.
What do you mean with not play for free? Explain that to me.
That they were just let on the team without paying.
Oh, so some people were disturbed that some people paid to play and some didn't.
Yes, Your Honor.
Do you have anything that requires that they pay in a contract?
That would be Coach Larry that he does, and he passed out those to the kids.
No, I'm asking you for your. He didn't put in $8,500. You did. Here it says, use some fees to catch up on my mortgage. I assume that's your home mortgage.
Correct, after the season was over.
Well, you can't do that. You can't do that, sir. Do you understand?
Jason Gabriel is accusing his former friend, Lawrence Sr., of owing him money after their boys' basketball team ended.
Go ahead, sir.
I put the money to the team. He runs the team. I can't tell him how to run his team.
No, would you have a contract, sir, that tells you what your $8,500 was to be used for, and the expectation that you were going to get that money returned to you via fees that were paid to each individual player? That has to be it. And in the event that they don't pay, who's going to pay?
Well, I do have a text message from the defendant saying, I did not use all the money. It did not cost $8,500,
Okay,
and I will pay you back.
That's what I would like to see. Because it was disbanded for whatever reason. All your reasons, sir, are hearsay. What is your first name?
Gianni.
Gianni, the reasons are hearsay. Why people left, they didn't like to be yelled at, they didn't like some people. That's all stuff that I can't process as a jurist in my head. All I know is this is a contract case. So now he paid $8,500, and did you, Mr. Senior, at some point say the $8,500 hasn't been all used up, and I'll give you back some of the money?
No, I didn't.
Okay.
And this is also a text message saying he used it for his mortgage and that he agreed to pay me $400 a month to pay back the money.
Coach, fees to catch up on my mortgage, use some fees to catch up on my mortgage, at least $1,500. And between operating costs, there is roughly $2,400 left.
Correct.
Oh, that's what you wrote to him.
Yeah, and I was willing to give him the money that the kids had paid up front.
No. There is roughly not the money that the kids paid up front, sir. You say to him in your text, after this was all over, because I assume that this is all over after the team is disbanded, there is roughly $2,400 left. So I'm going to have to work out sort of a payment arrangement, if you don't mind, which means you didn't have the money, but it was left over and you spent it on something else. And it's here it says, use some fees to catch up on my mortgage. I assume that's your home mortgage.
Correct, after the season was over.
Well, you can't do that. You can't do that, sir. Do you understand? Okay, well, this acknowledges several things. It acknowledges that he used $1,500 to catch up on his mortgage, right? And that, according to you and according to your son, whether or not you took a fee for yourself, paying your home mortgage is a fee. Do you understand that, sir?
I do.
All righty. So
I sure do.
You sure do. So $1,500, did you pay him back the $1,500?
No, because at that point...
No, the answer is no. And you said even after the $1,500 that you used to pay your home mortgage, there was still $2,400 left. That's what you said in here. That's a yes.
Yes, ma'am.
Well, then you add 24, and 15 is 009 is $3,900.
Yes.
Even my rudimentary math suggests to me that that is a correct number. Well, that's minimally what you owe him, your mortgage payment and the $2,400 left. You're suing him for $4,800.
Right.
This acknowledges 39.
Absolutely.
Prove to me any more.
So I went back to Mr. Senior and I said, I didn't necessarily believe that it cost $5,500 to run the team. I said, so therefore, you owe me $5,000. I said, you need to either get a loan and pay me back, or he said, I can't get a loan. I can give you $400 a month.
I'd like to see the exchange.
I said, if you're going to give
I'd like to see the exchange, just because you said, I think it's $5,000.
And this is where he says, I'd like to pay you back.
This doesn't say anything about $5,000.
And this is where I told him that he misappropriated money that was owed back to me, and that was his response.
Just because you said it, he doesn't acknowledge here in his answer that it's $5,000. Silence cannot be construed as acknowledging $5,000. Even the math doesn't fit in. You played more than half the tournaments. So
can we see how much the tournaments cost then, please?
No, I'm not bothering. That's nonsense. Put something in a contract. You're a contractor. Have a contract. Right now, he owes you $3,900.
And not for the uniforms?
No.
That has his team?
No, he says he doesn't have the uniforms.
Okay.
And I didn't go to 7 years postgraduate school to discuss a basketball uniform, a pair of shorts, and a pair of socks. I don't care.
The uniforms are $1,000.
Well, then somebody's overpaying for a pair of shorts. $3,900. Judgment for the plaintiff. Thank you very much. We're finished.
Thank you.
Court is adjourned.
I think it was unfair.
I'm glad she ruled somewhat in my favor.
Because he sponsored a team.
And yes, did I do it for my son? I did. But there was 11 other young men that I did it for.
Fighting amongst each other, poor discipline, and the lack of financial support from the kids.
When you have a group of 18-year-old young men and you don't practice and you don't kind of reel them in and show them that you're the coach and that you run the team, it can get a little hairy.
It is what it is.
I did what I did for these young men. Sometimes it works out, and sometimes it doesn't.
Me and Jason's are friends. I don't think this is a deterrent.
Always have contracts.
Okay. So I know that when we got the paperwork on this case that you really tried hard to give me a rudimentary lesson in basketball.
I did. Those years managing in high school really paid off today. So
yes,
learned
that's right.
a lot.
You managed.
I did a basketball team, so I know a little bit about AAU. A lot of the kids that played at the school that I went to had previously played on AAU teams, so I kind of get
What's
the dynamic.
AAU?
Oh, Amateur Athletic Union, AAU.
I never would have figured that.
Me neither. So they played on a lot of AAU teams before coming to high school, so I know a little bit about the structure. And when I read it, it's a nonprofit organization that kids play in to get exposure, hopefully to move up to the next level of basketball. But to me, I read it as he was sponsoring the team for $8,500, sort of like how you see in Little League, you know, Johnny's Pizza across the front of the
No,
team's
that
uniforms.
wasn't this.
But this seemed like a different type of setup, and to go through the coach directly. I'm not sure the very specific structure of who gets paid and who doesn't, who sponsors and who doesn't, but definitely paying your mortgage out of an $8,500 that was meant to start a team seems a little outside.
Yeah, well,
the
it's
scope.
outside the box, especially since both he and his son say they do this without compensation.
Mm-hmm.
Well, you don't have to take money and put it in your pocket. If you take money out of that account and pay your personal mortgage, that's getting paid. Yeah. It was not a difficult case, and the text messages made the whole thing a lot easier. Now I know that there were 5 people on.
Is suing homeowners Jeff McNally and Angela Klingenberg for property damage.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2164, Ritter versus McNally Klingenberg.
Thank you.
You're welcome.
Mr. Ritter, you own a piece of property,
That is correct, Your Honor.
and it's a residential piece of property,
That is correct.
and you use it as a business.
That is correct.
I would assume that this is your tenant.
That is correct.
Perfect. Could you stand up next to Mr. Ritter? What is your last name?
Mason?
Mason. These are your neighbors across the street?
Yes.
I live side by side.
So you're side by side, not across the street?
I live across the street.
Now, there came a time, Miss Mason, that you heard something that was unusual. Can you describe what you saw?
I was startled by the sound of a big thud and my dog freaking out and ran to the window. And so I jumped up, ran to the window where the dog as well was running toward, and looked out the window and seen the truck that had just hit the air conditioning unit.
Can you describe the truck?
A white truck pickup.
Had you seen that car before?
Yes, in the driveway next door to me.
So in his driveway?
Yes.
Did you see who was driving the truck?
I did.
Was it Mr. McNally?
It was not.
Who was it?
The young lady beside him, friend
Miss
across the street.
Klingenberg?
Yes.
When you looked outside, what did you see the truck do next?
As I looked out the window and made eye contact, I seen...
With her?
Yes, I seen Jeff at the back end of the truck, right by the AC unit, kind of backing her off a little bit, kind of gave her a raised hand.
So he was out there as well?
Yes, positioned behind the truck.
What did you do?
Well, I jumped up and then I ran and actually grabbed my phone to take pictures because I did not want to be responsible for what had just happened to the air conditioning unit. As I could tell, it had been moved and hit.
Do you have those photographs?
I did send those to Bob. He has pictures of those.
Kevin? Yes. Want to get them?
I immediately texted Bob as well, letting him know.
So that day, the 20th of August, you went, took photographs of the truck?
Yes, ma'am, and the yard and the air conditioning unit.
Okay. Mr. McNally.
Yes, Your Honor.
Where had you been camping?
We were camping in a place called McCall, Idaho.
Aside from you and Miss Klingenberg, who were there?
My son.
See how easy this is? It's going to get easier. Do you understand? Okay. Now, is this your girlfriend?
Yes.
Okay. Now we got that clear. This is your girlfriend. You and your girlfriend were camping. Your son was with you. And what you were doing that day was you were trying to unload the truck with the camping gear, correct?
Correct.
Is the camping gear heavy?
Yes.
So somebody was driving the truck and somebody was schlepping the stuff out of the truck to put it away, right?
Correct.
Now, Mr. McNally, you don't want me to believe that either you or stand up, or this guy were just twiddling your thumbs and you backed up the truck so that you left Miss Klingenberg to empty the truck, right? You don't want me to believe that.
No.
Because that wouldn't be true, and that would be foolish, and that would make you certainly unchivalrous, right?
Correct, Your Honor.
Okay. So when you were first confronted with this, you said, oh, my girlfriend wasn't driving, right?
Right.
So let's get it straight now, because that's what you wrote here in your answer. Oh, my girlfriend wasn't driving, my son was driving. That's not true. I don't know why you would choose to say my son was driving, not my girlfriend, unless she doesn't have a driver's license, because otherwise there'd be no difference whether your truck was being driven by you or your son or your girlfriend. Do you understand? No difference. Your truck being driven with you around hit his air conditioning unit. So what difference does it make? You have a driver's license?
I do not.
There you go. Perfect.
I was not driving, Your Honor.
Yes, you were. Yes, you were. You were driving, and he says you were. You see, and he says just a second, you didn't see his face just now. He says you were. Now, how did I know you didn't have a driver's license? Do you have a driver's license?
Yes.
Yes. But how did I know you didn't? Where do you think I got that from? I got that from common sense, because Mr. McNally doesn't look like a stupid man. And there would be really no difference if he drove the car, you drove the car, the son drove the car, his car caused damage. But in order to perhaps have insurance cover it, if he had insurance on the truck, do you?
My insurance had actually elapsed.
What? Okay, so it really didn't make any difference. If you had no insurance, you could have said she was driving. But didn't think that far. Okay, so that's why we're here. We're here because you let an unlicensed driver drive your truck that was uninsured that you took on a camping trip. Is this coming together for me?
It's close.
So now we got that straight, right? The next thing we have to take care of are the damages. I see that the outer part of this air conditioning unit was definitely hit. Now, the outside is merely a cover. So I need some evidence that this damage that he caused while she was driving damaged the mechanism of the air conditioner, because you replaced the unit and you want him to be responsible for the unit, right?
That is correct, Your Honor.
I have to see a photograph, because I don't have this photograph of the inside of this. I just have the photograph of the cover.
I do not have the inside, but I do have from 2 HVAC companies that did go out to service it. One that did the replacement, the other that came out second opinion, as Jeff had asked us to do, which we did.
Okay, I'd like to see it.
This will be the second, and this is the actual invoice for payment.
Oh, this is the second opinion. This says, second opinion call, 4-year-old Goodman air conditioning unit has been backed into. The unit has permanent damage to the condenser coil. Oh, well, that's the unit itself. That's just not the lipstick on it. That's the guts of it. This says immediate repair, replace condenser coil and damaged panels, 3961.
Correct.
Replacing the unit instead may be an option to consider. And to do the whole job, what did he want, $5,000?
The other side, $3,450 to replace the identical unit.
Okay, and to repair
it was less money to replace
than
it.
to repair.
Correct.
Okay. Do you understand that now?
I do.
Okay.
Thank you, Your
So,
Honor.
based upon your request, he got a second opinion. Second opinion was for more money to repair. He chose the lesser of the two, which is to replace the unit. The ball is in your court, sir.
Garrett was actually driving.
I don't believe it. You've had some time to reprocess it all. You would have had the boy, that's what you raised them for, strong boys. You wouldn't have said, well, you just sit in the car while my girlfriend unloads it. Take the hair out of your eyes so I can see your eyes. Perfect.
And later today,
I want to know how much you received from the insurance company.
$874.53.
Then can you tell me, I had a check from the insurance company, which was a little over $1,300 from their appraisal.
No, that's incorrect.
Well, that's what you wrote, madam. That's your signature. That's what you wrote.
Robert Ritter claims homeowners Jeff McNally and Angela Klingenberg owe for property damage after hitting his air conditioner.
Your car, uninsured as it was, driven by your girlfriend, damaged his property. Why don't you think that you're responsible for it?
We don't believe we hit it.
The damage is on your truck, sir. There's a picture of your truck here. You want to see it? Or you don't have to see it. You'd be better off just saying, you know what? I don't have the money. You'd be better off just saying, because we started out wrong, you and I, Mr. McNally. And the wrong started off was claimed his son was driving, even though Regina clearly saw his girlfriend. Okay, so that was a fib here.
Actually, Your Honor, if I may, there was just one front seat, a bent seat, and she was sitting in the middle, and Garrett was actually driving.
I don't believe it, sir. You've had some time to reprocess it all. That's not true. she was driving, because if you were unloading the truck, you would have had the boy. That's what you raised them for, strong boys. You wouldn't have said, well, you just sit in the car while my girlfriend unloads it. You wouldn't have said that. Put your hand down. Take the hair out of your eyes so I can see your eyes. Perfect. Thank you. Judgment for the plaintiff in the amount of $3,800. It's not a good idea, Mr. McNally, to show your son that it's the right thing to do, not to tell the truth. That's a very good lesson that parents should teach their children right from the get-go. And accepting responsibility for what was clearly an accident. I mean, she didn't mean to back into his air conditioner, right?
Right.
It happened. It was an accident. That's why they don't call it an on purpose. It was an accident. But once you have an accident, you have to accept responsibility. That's what you want to teach him. And if he lifts his hair, he'll be able to see and be able to hear better. We're done. Thank you.
This court is adjourned.
We were all sitting in the front of the bench seat, so I was in the middle, and I think when she initially came out, she saw me sitting in the truck, but maybe she assumed I was sitting in the driver's seat, but I wasn't.
Nope, my vision was great that day. It did make me jump, and my dog was freaking out, so I definitely knew something hit the house.
I told him that my son and I were emptying firewood and that he may have hit his AC unit.
It's just sad, you know, that they had to do that and that the young man had to be involved when he really didn't do it.
That case was a great demonstration of how being well prepared and doing the right thing can make the justice system work for you in the right way. He had all of his evidence laid out exactly how he needed to present it to you, and he had the damage evidence, he had the photographs, and he did the right thing. He didn't try and get a whole new unit for the $5,000. He said, I'll get the 2 estimates if that's what you want me to do. So it just shows how being prepared and having all your ducks in a row can really benefit you when you come into a court system.
But my problem was telling the lie after you've sworn to tell the truth in front of his son, because those things remain embedded in your children. You want to be a good parent. The first thing you have to teach your children is to be honest. And if he sees that his father and the father's girlfriend are dishonest, that will become part of his fabric. Yeah. That's a mistake. So
I agree.
But I think you are correct that it was a good lesson in preparing a case that made it easier to try.
True.
Case 2171, Cosby versus Warren. All parties, please step forward.
Shalea Cosby is suing mechanic Kevin Warren for the repair cost of a car and lost wages.
Okay, Miss Cosby. According to your complaint, you parked your car near your home on a side street. You came out the next day and you found your car vandalized. Car was a 2017 Hyundai Elantra.
Correct.
Did you buy the car new or used?
Used.
And how much did you pay for the car?
I put a down payment of $1,350, I believe, $1,350.
So you financed the whole thing?
Yes.
And you have to have insurance on your car. You have to have liability, collision, all that other good stuff because you have a loan.
Right.
And you did have insurance. Now, came out, you looked at your car and it was vandalized. What was wrong with it?
The back window was shattered, and along the side passenger top quarter panel, back passenger door, and the passenger mirror, it was shot.
You have photographs of it?
Yes.
I'd like to see it.
Right here.
Okay. Did you notify your insurance company?
I did.
On what date?
The same exact date, which was July 22nd, is when I came out and found my car vandalized. I submitted a police report. I have that right here.
I'd like to take a look at it, please.
And
okay, nothing with nothing. Okay, so you told the police about it on the 22nd.
Yes.
And when did you bring it in for the defendant to take a look at it?
That was August 18th.
She brought the car into you in August?
Yes.
And how long have you been in the auto repair business?
16 years.
So you've dealt with insurance adjusters before?
Yes.
And did you make the appointment for the insurance adjuster to come and look at the car?
They never came to look at it. Sometimes they just have me submit photos if they don't have anyone in the field to come look at the vehicle.
Okay. Now, when the plaintiff came in and brought you the car, did you have a discussion with her?
Yes, I did.
And I want you to tell me, the best of your recollection, what she told you and what you told her.
Okay, like she said, she brought me the vehicle on August 19th, and she told me she took it from another shop. She had a problem with another shop getting the repairs done.
Tell me what kind of problem you had with another shop.
It was no problems with the other shops besides they didn't want to do the estimate on it. and told me to talk to my insurance about it. And my insurance told me to find my own shop. And that's when I found it.
Just a second. Did your insurance company send you to the first shop that you went to?
Yes.
And for some reason, that first body shop was unsatisfactory to you.
Mm-hmm.
So you took it to the defendant. This is what the story is. The story is the defendant still has your car, right?
Mm-hmm.
And he's keeping your car because he says you didn't pay for the repairs. It's your position that you gave him the entire check from the insurance company. Is that your position? Speak. Be very careful what you tell me.
This is how her car looked when she brought it to me.
Oh, Miss Cosby, I have a feeling that you're not going to like the outcome of this.
Oh, no, I'm legit all the way around.
Oh,
so
really?
And those are the afterwards
Just
pictures.
a second. Hustler.
Oh, it's not a hustler at all, man.
Absolutely a hustle.
Shalea Cosby claims mechanic Kevin Warren owes for the repair cost of a car and lost wages.
The insurance check went to you to cover the damage to the car.
Correct.
I'd like to see the check receipt that you received from the insurance company. Look, we're going to have trouble with each other, madam. Do you understand? This isn't the only check you got from the insurance company.
If you're talking about a check in 2020, that has no relevance to 2022 vandalism check.
I want to know how much you received from the insurance company.
$874.53.
Then can you tell me, I had a check from the insurance company, which was a little over $1,300 from their appraisal.
No, that's incorrect.
Well, that's what you wrote, madam. That's what you wrote. That's your signature. That's what you wrote.
I see the paper. The totaling was $1,374.53. I didn't receive a full $1,374.53 check from my insurance. I received $874.53 and had to pay my deductible of $500.
When you brought your car into Mr. Warren, tell me what the conversation was.
Before I got to him, I let him know what was going on, what I was going through.
No, not let him know. I asked you what you said to him and what he said to you. First of all, you didn't like the first place that the insurance company sent you to. I don't know why. All I know is when you're dealing with this kind of thing, everybody's trying to make a little bit extra. And it's been my experience, and maybe I'm wrong, that when you have a little accident, you take your car into a body shop. Very often, if that's their business, they say, this is what you want fixed, this is what the damage was. And the person who runs the body shop or the owner of the body shop will say to you, I'll take whatever the insurance is, I'll work with the adjuster. Mm-hmm. That's what they usually do. Correct, sir?
Yes.
Yes. And in this case, is that what happened?
No.
Is what I'm asking you. Because your complaint is that he has your car, won't give it back because he's put a mechanic's lien on it because he says that he did $6,000 worth of work on the car.
He did work that was not approved by me nor my insurance.
I'm just telling you. That's what he says. He did $6,000 worth of work on the car.
Okay.
Okay? But I have to tell you, Mr. Warren, that has been my experience, and I'm very old. That when you take a car in that's been in an accident, they say, you know what, I'll work with your insurance company. And we all know what that means. That means that whatever your insurance company gives you, they'll send me the check. That will be what I'm going to accept for the work. Now, what you're suggesting is that she authorized you to do $6,000 worth of work, and you didn't speak to the insurance company.
I spoke with them plenty of times.
Oh, what did they tell you that they were sending her?
I have it here.
I'd like to see it.
I have 3 estimates here.
No, I want to see from the insurance company.
They're the insurance company estimates, not mine.
I'd like to see it.
Okay, here's the first one. Like she said, when she first brought her car to me, she had this one already for $873. Mm-hmm. Okay, so then what we do when we see more damage, we put what you call a supplement in. So I put a supplement in, and that's when they told me she has 2 claims. She has a claim for the auto body damage and a claim for the vandalism. The $874 is for the vandalism. If you look at these other 2 estimates, it's a totally different claim number.
May I see it, please?
That she put the claim in for. So these other 2 are for the auto body portion.
Not for the vandalism.
No, it's 2 different claims.
When she brought you the car, Was there body damage on the car?
Absolutely. This is how the car looked when she brought this to me.
I'm not just talking about that. Can I see, please?
This is how her car looked when she brought it to me.
Oh, Miss Cosby, I have a feeling that you're not going to like the outcome of this.
Oh, no, I'm legit all the way around.
Oh,
so
really?
And those are the afterwards
Just
pictures.
a second. Just a second. This car was in a bad accident.
Yes, correct.
This car was in a bad accident. Hey, this car was in a bad accident shortly after you got it.
Correct.
Right. And you got a check from the insurance company to fix this.
Correct.
How much was the check that you got from the insurance company to fix this?
The total in amount, I'm not sure, but I think it was like 2001 or 2002.
And you didn't have it fixed.
No one wanted to fix it.
Well, he fixed it. Just a second. Hey, Miss Cosby, he fixed it.
Without
Just
my
a second.
approval.
What did you do with the $2,000?
Oh, I paid my own personal bills because no one wanted to fix the car, so I have to keep living.
Your case is dismissed.
Okay.
How's that?
That's
Your
fine.
case. Hustler.
Oh, it's not a hustler at all, man.
Hustler. Absolutely, absolutely a hustle. I actually think you're a hustler. That's why I'm not helping you.
That's fine.
Because you had an accident in 2020, you got a check from the insurance company to fix it. I don't know how much that check was because you don't have a copy of that check. You brought the car into him and said, now I have a broken back window. I have a feeling, and I know it's only a feeling, but this is my program so I can vent that feeling, that you went to the first place to fix the car and you said to them, I want you to fix the front and the back, and they said no. That was for something else. You already got paid
That's
for that.
incorrect. They
So you
didn't
went to
want to
him.
get an estimate altogether.
Yeah, I don't believe you.
You don't have to.
I don't. Well, I don't. I don't.
have to.
That's why your case is dismissed.
That's fine.
Now I'm getting to your counterclaim. Because you put a mechanic's lien on the car?
Yes, I have it here.
Great. So you've got a mechanic's lien on it. She can't sell it. I'm not giving it back to her. I'm not ordering it back to her. You have the car?
Yes.
Sell it.
I need that signature on that paper to be able to do so.
It doesn't matter.
From whom?
From her. Or you can sign it just to set.
Oh, I can't.
To turn over.
Oh.
This says she has no more interest in the car.
I can't. She does have an interest. The car's got a lien on it, sir.
Absolutely.
Okay? You're going to have to pay off this note. Do you understand? I don't think you're going to be able to get the money after you pay off the note. But you fixed the car.
Absolutely.
And I think that you're entitled to money for fixing the car on your counterclaim. She's going to pay on your counterclaim because I'm not sure whether you're going to be able to get any money on this car. I don't know what's going to happen with this car. I'm just not returning it to her. Do you understand?
Yeah.
I'm going to try to make you as close to whole as you can be because I think what happened to you was a hustle. That's what I think. Usually I don't side with mechanics. It's just been my experience. But I think that...
I'm glad you changed today.
I think that this is a hustle. $3,800, judgment for the defendant on the counterclaim. Thank you very much. We're done.
Adjourned.
Oh, I appreciate her decision. I believe she ruled the right decision because I brought all my paperwork and it wasn't no other way to rule it. Well, she said she wanted me to help her get her car fixed and that she was gonna get the insurance and pay me like she was supposed to do, but I guess once she got the money, she changed her mind. All mechanics aren't bad.
That was a surprise.
That was.
For me.
Did not think it was going to go that way when we reviewed it
When
earlier.
we talked about it, I looked at it. When we spoke about it, I said, you know, sort of using my life's history. Take the car in, don't worry, I'll work with the insurance company, does a little bit more work. The insurance company sends a check for a little less. But he wasn't at fault. She was the hustler.
Yeah, he wasn't trying to make an extra quick buck like a lot of mechanics that we've seen. He did the work.
He did the work. Because she didn't bring the car in there just for the back windshield. It's a hustle.
It seemed that way. As soon as somebody says, oh, that thing from then has nothing to do with why we're here now, immediate red flag.
Bing, bing.
Yeah.
Anyway, I'm glad that worked out. And
me too. I'm glad you gave him the money.
Fatoumata Diallo is suing salon owner Kanaya Taylor for 5 wigs.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case number 2008, Delano versus Taylor.
Thank you.
You're welcome.
Briefly, and then I'll get into specifics. You sold over the internet some wigs. You claim you sold them to the defendant.
Yes.
They were charged on a credit card. According to you, it was the defendant's credit card. You shipped the wigs. The defendant, according to you, received the wigs, then challenged the credit card charge, and the charge was reversed so that you did not get your money. And Ms. Taylor kept the wigs. It is Miss Taylor's claim that you never sold her the wigs, that you sold the wigs to clients of hers, and if they didn't pay you, that's not her problem. Is that your defense?
Yes, ma'am.
Okay, yes, ma'am. Stop jumping up and down because it makes me seasick.
Okay.
Stand still. I can't. You can't. You want a stool to sit on?
No.
You sure?
I just have anxiety.
Okay. Miss Diallo, how long had you been in the online wig business?
3 years now.
And on what date did Miss Taylor contact you?
October 1st of 2021.
Had you ever dealt with her before?
I haven't. A customer of mine actually referred her to me.
You had not dealt with her before?
Correct.
And her first order was for what?
A 34-inch deep wave wig unit.
I don't know what that is. Tell me how much it cost you.
$391.
And how much did you charge Miss Taylor?
$491.96.
And you shipped it to her?
No, I didn't.
Where did you ship it?
Right now, I didn't ship anything at the moment.
Okay, so she ordered the first one for $491.
Yes, and then after that, I shipped after.
How many did she order all in total?
In total, 5.
Within what period of time?
In the span of 4 days.
Okay, and Miss Taylor, you do not deny the fact that 5 wigs were ordered in a conversation over the internet with the plaintiff. Is not an answer.
Yes, ma'am.
Do you have a copy of those orders?
Yes, ma'am.
I'd like to see them, please. Who's Joyce?
One of my clients. Your Honor, that's her.
Shh. Do you have a MasterCard?
No, ma'am.
Did you ever?
No, ma'am.
Do you have any credit card?
Yes, ma'am.
How long has Joyce been a client of yours?
Probably about a year.
When you say she's a client of yours, she comes to your salon?
Yes.
You have a
my
salon?
Apartment. No, I have to do my hair out of my apartment.
So she comes to your apartment?
Yes, ma'am.
And how do you know when she wants to come for an appointment?
She'll text me. She'll DM me.
Okay, so she texts you, which means she texts you from a phone.
Right.
Which means that you have your phone, which shows her text messages.
Not.
What do you mean, not? If she texts you for an appointment, then you know how to contact her.
Yeah.
And she knows how to contact you. I want to see that. I want to call her.
I don't have that phone anymore.
Get it. You have to understand where I'm going. Do you understand?
Yes.
Yes, you understand where I'm going. Who is that?
My boyfriend.
Your boyfriend. What does he have to do with this?
Because he was at the house when her and someone else came to the door.
I don't care.
Okay.
If I were coming to court today and I knew that there was going to be a certain amount of proof that involved some person who is named Joyce, and order confirmation email was sent to Joyce at your email address.
Right.
Right. And Joyce is somebody who was a client of yours for a year, not too long ago, who's no longer a client of yours. Not isn't an answer. Yes is an answer.
Ma'am.
But you can't give me her number to call because you lost your phone.
Yes. And she blocked me after I started asking her about the dispute.
Well, just a second. Well, that's 2 different things. You see, if she may have blocked your number, she won't block my number. That's not what you told me. You told me you don't have that phone anymore.
I don't.
Well,
and she blocked me.
How do I know that?
Her. I don't know.
How do I know that?
Did.
Yeah, right. Okay. Dora Dynasty, is that your?
Yes, that's my business.
That's your business. Well, these wigs were sent to Dora Dynasty.
Right.
Right. I know, right. And who is?
A client.
And is still your client?
No.
No. Okay. You seem to be having a lot of trouble in your business.
How?
Yeah.
I've been having this trouble ever since the wigs have got delivered, and she hit me about a dispute.
Let me explain something to you. You purchased the wigs based upon her conversation.
I got them to my house.
Just pay careful attention to me. They were all delivered to you.
Right.
That means you bought them. If somebody stiffed you, that's not her problem. But according to her, and you acknowledge that she sent you 5 wigs, and the is not an answer. Do you understand? You following me? Okay. What was the total value of her purchase?
$21.96.
And can I see the reversal of that charge on your credit card?
Yes, ma'am.
Now, at some point, your credit card was charged. At some point, your credit card was charged. That's either a yes or a no.
No.
Whose credit card was charged?
My client's.
Which client?
I'm not sure. Whichever wig she said was disputed.
You said in your answer you kept all the wigs.
No, I didn't. I didn't keep all the wigs. They got delivered to my house. 2 of them I installed, and the rest they picked up.
The wigs got shipped directly to my salon.
The wig shipped to my apartment because I was going to do their hair. I told them about the vendor.
Are you trying to tell me that despite the records that she has, that you were the contact person on all of this,
right?
Nobody else,
right?
Just you,
right?
That you gave these wigs to somebody else,
They
to 4
paid
other
for
people.
'em.
They paid who?
They paid her. They paid for the wigs, and they got them shipped to my house.
Were 4 different people charged for the wigs?
Yes.
4 different people?
Yes. She did 5 different transactions.
Are you telling me that the 5 different transactions were all her?
All her.
That makes my life easy. So what you're saying to me, she charged it on 5 different cards.
Yes. No, I didn't.
But she is all of those people.
All of them.
How?
I'd like to see it.
Please.
And Your Honor, she also admits it on Twitter. She doesn't actually know I have her Twitter account. And this is how she gets them. She orders,
May I see it, please? See how you're smiling? Bad. She should have left you home.
Man, please.
Do you understand? She should have left you home.
Nah, they just ain't
You
communicating
should have left
right.
you home.
They ain't communicating right.
Still not a good look from you.
Fatoumata Diallo claims salon owner Kanaya Taylor owes for the cost of 5 wigs.
What's Beauty?
That's her business name. Business Twitter.
I don't have a Twitter.
Right.
I have an Instagram, 2 of them.
I have
and a business page. That's what I have. I don't have a Twitter. Do you have my Instagram?
I do.
Don't talk to each other. Don't ask her any questions. That's so interesting.
What?
From Dora Salon, is that it? Or Dora Salon?
Yes, ma'am.
No.
I have her LLC.
Just a second. Yeah. Can I see that?
Yes.
Yeah.
It's Dora Dynasty.
And here's her LLC, so it matches.
I'd like to see it.
And here you go as well.
Well, this is from Beauty at...
No.
What do you mean, no?
No, my business name is Dora Dynasty.
Yeah. Dora Salon 1 Beauty, Dora Dynasty LLC, Dora's Dynasty.
Right.
And about the same time, the tweet is over 2,000 in wigs. I'll smack those. And then on the 13th, you write, my wigs come tomorrow. And then on October 11th, I'll be wrong if I dispute it once I get it. And then I don't know what did the...
Because,
what is,
ma'am,
just a sec, I'm reading something. Is not an answer. I didn't ask you anything. What does that mean, Sarah?
It's just an emoji. Like, so what? I don't care.
Oh, I'll be wrong if I dispute it once I get it. So what? But was so rude I can't even ask them questions, telling me I didn't read it. And then she writes, see how you're smiling? Bad. She should have left you home.
Man, please.
Do you understand? She should have left you home.
Nah, they just ain't
You
communicating
should have left
right.
you home.
They ain't communicating right.
I paid all this money for these wigs and these slow rolling. Wow. I assume that those people, the clients that you were talking about, was slow rolling. Would that be a fair statement? I mean, I'm not familiar with all of this. And then you show me in these tweets, or whatever they call them, a picture that was put up by Boo. Is that a name?
Yes.
Now, what is that?
That's her client actually contacting me and telling me that she's charged her for the wigs and that she was never a stylist to begin with.
How did I upcharge the fee when they paid for it themselves?
Nobody hears you, madam. Okay, so you acknowledge you got them. Your statement is you no longer have them. She didn't make a deal with you. She made a deal with 4 other phantom clients, 2 of whom either you lost your phone, the dog ate your phone, you don't have the number anymore, you don't have the contact anymore, but we don't know how to get in touch with him. And then there was somebody that actually was wearing one of the wigs that she didn't get paid for, that she got from you.
That's not true.
Could I see the invoice and the chargeback, please?
Yes.
Still not a good look from you.
Well, I'm glad.
Yeah, not a good look.
It's funny because it's not true.
Not a good look. You the boyfriend?
Yeah.
Stand up for a minute. Just have a couple of questions. Tell me your name.
Braylon, right?
What do you do for a living?
I'm a barber.
Do you live together?
Yes.
How long have you lived together?
Going on a year.
So you were living with her when these wigs were delivered?
Yeah. Yes.
Yes, would be an answer. Were you there when she opened the wigs?
One wig she had to put together for a client. Then she opened, she told me she was doing. I know her. I don't be in no business like that.
So the answer is you were only there when one wig was delivered?
I was only there when she opened one wig.
When she opened one.
And I took her to go pick up a wig from her.
Did you drive her there?
Yeah.
Did you go in with her?
No. She came outside. She walked across
Just
the
a
street and
second.
got it.
Don't speak. Don't speak. She walked across the street and got it.
From her, yeah. Downtown.
Your Honor, she was actually driving. Cause,
Do you work out of the apartment as well?
No.
You work out of a shop?
Yes.
Are you ever there when your girlfriend is working on clients in your house, in your apartment?
Yeah, I've been there.
Often?
Not really, I be gone. Working hours, I'm working. If she work at the house, I'm working at the shop.
How many rooms are in the place where you and the defendant live?
At the time, we was in a two-bedroom apartment.
And who was there, just the two of you?
No, we had a roommate.
So you had one bedroom for yourselves, you had a roommate, and then there was a common area, kitchen, living room, right?
Yes.
Where did she conduct her salon business, in what room?
What it would be like dining room area connected.
In the dining.
Yeah.
And is that where she kept her equipment?
Yes.
Is that where she kept her materials?
Yes.
How many wigs did you see in that dining room area at any one time during the time you were living there?
Maybe one she was working on the door, two, maybe two at the most.
You paid rent in the apartment?
Did I pay rent? Nah.
Did she pay rent?
Yes.
How much?
It was like, what, $1,200?
Don't ask her anything.
$1,200. I don't pay the rent, $1,200. I don't pay it, so I don't know.
Why don't you pay anything towards rent?
I don't have to pay the rent if I pay the bills, I pay car notes, I pay different stuff. We 50-50.
Well, if it's 50-50, then you would also pay part of the rent.
Not if it add up to both our car notes, rent, which really be a little bit more.
Okay, so you pay the other bills, she pays the rent.
Yeah, I moved in with her. I ain't lived there the whole time. I told you it only be like a year. She was already staying there. I moved in.
With what did you pay the car note? With a check?
No, I pay with either a car or my money.
Your girlfriend, does she have a car?
Does she have a car?
Yes, yes or no?
Not right now. She did.
Did she?
Yes.
What kind of a car did she have?
Chevrolet Sonic.
And what happened to that car?
It got, whatever, repoed.
It was repossessed.
They was scamming me on my insurance.
Just a second. I didn't ask you anything. I'm asking your witness.
Okay.
You brought him.
All right. I'm not the only person you suing. If I pulled up
nobody
and bought a vehicle, why wouldn't I?
Nobody is listening to you.
Okay, well, can I leave?
No.
Fatoumata Diallo has accused salon owner Kanaya Taylor of stealing 5 wigs. Kanaya says Fatoumata was trying to scam her.
So the car was repossessed. When? Don't look at her. Give me a month, give me a year. Was it recent, in the last 3 months, 4 months?
I can't give you a month.
So it was repossessed because of non-payment of whatever the note was, because that's the only basis to repossess a car. Okay. Now, you say you're not living in that same apartment anymore. You were living in this 2-bedroom apartment with a roommate.
Mm-hmm.
Uh-huh is not an answer.
Yeah.
Yes is an answer. And you're no longer living in that apartment.
No.
And what happened to that apartment?
I moved. She moved with me.
Okay. You moved when?
November.
November of 2021.
Yes.
Just about the time of all these disputes over wigs. Did your roommate remain in the apartment?
Yes.
Did you have a lease in that apartment?
Yes.
Was your lease over, or did you move out during the lease?
It was over, and I renewed it for my roommate.
Now, the lease was in your name.
Mm-hmm.
Uh-huh is not an answer. Yes is an
ma'am.
answer, and you renewed the lease even though you moved out.
Yes, ma'am.
Where are you living now?
In Conyers.
What kind of place?
House. And I pay all the bills.
And what does your girlfriend do?
She works.
What does she do?
She does lashes. She does hair. She does nails. She's a entrepreneur.
Does she have a website?
Yes.
Yes. What's the name of her website? You think?
Yeah, I think. I don't be on her. I don't shop with her.
Got it?
Looking.
Did you have a conversation with Miss Taylor about these 5 wigs? Did you have a conversation with her?
Yes.
Do you have a cell phone?
Me? No.
Did you ever have a cell phone?
Yes.
What happened to your cell phone?
I broke it, so I went on another one.
And you didn't get another one?
It have to get sent to the house. I just broke it. Like, I just broke it.
You just broke it?
Yeah.
So
last
you
week.
have a cell phone. Tell me how you broke the cell phone.
I got real angry and I threw it.
You got angry with somebody?
Yes.
And tell me how your girlfriend lost her cell phone.
Oh, she gave it to me.
And when did she lose her cell phone?
She gave me that phone. I bought her another phone. She gave me that
So
phone.
she gave you,
around.
just a second. So she gave you the phone that she had been using.
Yes.
Which had Joyce information on it. That was the phone she gave you.
I guess so. I don't know Joyce. I don't know who Joyce is.
Sit down. Ms. Taylor, you want to be in business, you have to pay for what you ordered. It's absolutely, I'm not speaking to you, it's absolutely outrageous that she sent you these wigs, they were delivered to your house, and she not only doesn't have the wig, she doesn't have not only her profit, she doesn't have any money. And you've got a lot of clients that you can't identify and phones that got lost and information that you don't have. And information that you don't have, that you don't have. Clients that are no longer clients, that blocked you. I mean, people who block you after you work for them for a year, that means that you're either doing a lousy job.
No, because the way she came at me, I actually chumped them off because I feel like you're messing up my business. So I chumped them off, and I guess she didn't want to reply, and she just blocked me.
2196, judgment for the plaintiff.
Your Honor, I have other text messages. I was out of business for like a month and a half.
I have to tell you something. I can't discern whether you lost business or not because of this. I cannot discern that. I can give you back the money that you lost as a result of shipping her 5 wigs and not getting compensated for it.
And I also have court fees, and I ordered a PI as well.
But
just a second.
More people
that I will
me
hear.
for wigs.
What were your court fees?
I'm not the only person you suing. If I pulled up
nobody
and bought a wig, why wouldn't I
nobody is listening to you.
Okay, well, can I leave?
No.
'Cause it's
Court fees.
like.
And I also have my incident report that day.
Just a second. Would you please just give me the court fees? You said you had court fees and you hired an investigator.
Yes, I did.
And I'd like to see that invoice, because that you're entitled to.
I have the text messages with my PI.
I don't know what this is. I don't know what this is that you're handing me. I asked you what the court fees were.
I have my PI phone number.
You have nothing.
I didn't print out my court fees, but I do have my more.
Do you have an invoice from the investigator that you say that you hired?
Yes.
And the work that they did?
Yes, I have all the messages.
I don't want messages. I need an invoice, a payment.
I did a payment, $400, and we have the text message trying to find her everything.
Can I see it, please? It was $250 for skip tracing and $150 for service.
My sales went down.
Just a second. Did this person serve her?
Yes, they did.
2196, judgment for the plaintiff. That's it. We're done.
This court is adjourned.
I never did it. You know, I just got it sent to my house.
We went through everything. We had to go through birthdays.
It's like saying, I know a friend that they know how to cut hair.
Text messages, everything.
And then you don't like your haircut. What you want me to pay for your haircut? Like, girl.
We literally hawked her down for the information.
She honestly messed up my clientele.
It would be easy to be forthcoming with me and say, these are the clients who I sold it to. I gave her the information. They were supposed to pay her, whatever, but she didn't.
A lot of running around.
A lot of running around. And there's no question that the plaintiff sold her those wigs. She made a markup. She made a 25% markup. That's okay. And I'm certain that she put in the wigs and made her own markup. Yep. You know, that's commerce. But this ability to reverse charges on a credit card and to have somebody, and it's usually just a person, we're not talking about a committee or a tribunal that determined whether or not the charge was legitimate, just to reverse it. And then where are you? You're left without your product. Very frustrating.
It's a double-edged sword. It can be very useful. I've had to do that on a few different occasions. And the process is very hidden and sort of behind the curtain. And I fear for people like the plaintiff who run their own business, hardworking people who make the best money on the internet because there's no overhead fee of running a store. But these are some of the risks and things that you have to ensure before you get into business.
Well, too bad. Yeah. Too bad people don't do the right thing. If they did the right thing, we'd be out of business.
Is suing her client, Danny Velasquez, for dance class fees.
Court coming to order. All rise.
Have a seat, please.
Hello, Judge. Case 2086, Renner versus Velasquez.
Thank you.
You're welcome.
Miss Renner, you run a dance studio.
I do.
How long have you had it?
30 years.
And what age children do you teach?
We have a Mommy and Me class, which starts at 18 months, and our oldest student is 19 years old.
And Miss Velasquez has a daughter. And she was at your school during what period of time?
She started in June of 2020, and she quit in June of this year.
Your lawsuit is simple. You claim that Miss Velasquez owes you money for her daughter's dance lessons.
Yes.
The defendant actually disavows owing you any money. She said that you actually behaved in a mean-spirited way in not allowing her daughter to finish her recital. So I'm trying to think back to my days when I was 6 and 7. And if I remember correctly, the name of the school that I went to, and I know that this is not something that everybody is breathless to hear about, but I haven't had one of these cases. And I was thinking back to Miss Nottage, who had a dancing school in her home on Parkside Avenue in Brooklyn. And I do remember that you took classes I took toe, tap, ballet, and acrobatics, which was not my strong suit. Any of them, none of them were my strong suit. Father always said that I should sue the city because they built the sidewalk too close to my behind because my legs are short. So being a ballerina was really not physically possible for me, but in my mind, I thought I was a ballerina. Anyway, as do most little girls, I assume. So you worked during the year, and at the end of the year of your dance class, I remember you gave a recital. Everybody got all excited and dressed for the recital. I assume that's what happens in your class. Yes, that's a yes.
Yes.
Did you have a contract with Miss Velasquez?
I have a registration form which acknowledges receipt of studio policies.
Well, policies is not a contract, but I'll take a look at it anyway. The question is, do you have a signed contract with her?
No.
Okay. May I take a look at that? According to these policies, which are not a written contract because she has not signed this document in particular, you say you acknowledge receipt of it. What it mostly is tell them what the instructions are and give you a release of liability. It does indicate here that full tuition is due on the first class of each month. And how much was the tuition for Miss Velasquez's daughter?
From January through June, it was $170 a month. And then from September through December, it was $165 a month.
Okay, so around $170 a month. And I assume she was current on her tuition in 2020. And in 2020, did Miss Velasquez make her payments on the first of each month?
Well, I can't say exactly on the first, but yes, it was always current, which is why.
That's not what I asked you. Was it made pursuant to your policies here on the first of each month?
I don't know. I don't remember specifically.
What about in 2021? Were her payments made on the first of each month?
No.
When did she stop making payments in 2021 on the first of each month?
Well, I have emailed spreadsheets here, and so starting in December, she asked me if she could make small payments, increments throughout the month because she was a single mother and wasn't able to make the full payment on the first.
So you said yes, that she could make payments incrementally. And do you have that same arrangement with some other parents?
I do.
How many other parents do you have that arrangement with?
Well, anybody who asks in...
How many? You run the school.
5.
How many students do you have?
5.
Okay. So you have that arrangement with this mother plus 5? And that is inconsistent with your policies.
Yes.
That would be a yes. Now, tell me what happened, Miss Velasquez, that caused you to fall behind in your payments. You acknowledge you fell behind in your payments.
Yes, I do.
When did you fall behind in your payments?
I asked Ms. Renner if I could start making payments in September of 2021, which I have written as well, if you would like to see that. And in October, I didn't pay anything because my father passed away. And I explained that to her, and then I made up for it in November through payments, and I just continued to pay as I could with being a single mom.
Well, that's not a reason to not pay her, being a single mom, as you could. You understand that?
Yeah, absolutely.
Okay, so I'm sure you're doing the best you can. You're trying to give your little girl, how old is she?
9.
9. Trying to give her the best possible experience. It's all wonderful, but this is her business. And if you owe her money, then you owe her money.
Mm-hmm.
Since the policies are honored and sometimes not, there is one part of your policy, even though that this is a contract that I actually find ridiculous, because in your lawsuit, you claim you're owed $946 and $7,169.76 interest. That's not happening. And it's not happening. You gave me an easy out because you really don't enforce your own policies.
I try to be kind to people who
and I
need
try
help.
to be kind too. Being kind is not suing somebody for $900 and suing them for $9,000. That's not being kind, because you know there's no question that you agree that you owe her some money.
Yeah.
Okay. But it's an unconscionable. Even if there was a contract for it, I would probably find it an unconscionable piece for somebody who owes you less than $1,000 and you want $7,200 because it includes interest. I find that ridiculous. How many students were in Miss Velasquez's class?
Approximately 18.
When you say approximately 18, the number varied based on what?
Well, my memory, it was either 18 or 19 children. I don't remember how many. That's a very large class.
Are you the sole teacher?
Well, I do the ballet, and I have a teacher who teaches the jazz class.
Your daughter takes ballet or jazz, or both?
Yeah.
Your daughter stopped going to school when?
May 17th.
Tell me the circumstances.
That was when I got a ledger from the studio that said that I owed $965. And my math was thinking I was closer to like $360. So I kept messaging and asking where the confusion was. And I didn't get a response until May 27th.
That said what?
That said I owed $1,300. And this was from Miss Jenny.
And that was for late fees? What was it for?
The dance team and the costumes for the recital that was coming up.
Okay. Well, do you have a ledger? And I'd like to see your ledger. So far, I have, according to you, what you owe, because you did a breakdown of what you owe. It is your claim that you owe $846, correct?
Yep.
And she says you owe $946. That's without the interest and the late fees.
Yeah.
So you are actually, based upon raw numbers, $100 apart.
I have an email from her stating that she owes $947.
I'd like to see it, please.
And later today.
Do you keep a certain amount of clothes at Miss Barnes' apartment?
No, Your Honor, they're usually in my truck.
So you stay with your mom?
Yeah, that's my primary residence. Like, it's maybe two days out of a week.
Mr. White, this is what we're getting. You see where we're starting to smile now?
Jennifer Renner claims her client, Danny Velasquez, owes for dance class fees.
Okay, so in this email, you acknowledge owing $586 and then $360 for team. What is team?
They did like competition teams that I allowed my daughter to be on. Before I let her audition, I made sure that Jenny was okay with my payments, and I sent it all in.
No, I'm just reading the email, which seems to acknowledge that you owed her $947.
Yeah, so the team portion was $361, which is what I thought was owed.
No, you said team, and your regular tuition said that I owed $1,301 when I only owed $586. So $586 and $361 and $947.
You're correct. I just couldn't get any accurate numbers.
I'm taking your numbers that you acknowledge.
Right. First she said it was $1,647 I owed, then she said $1,400.
Right now I have, she says amount owed $946. You said it was $947. So let's say it's $947. And that's without late fees and without interest. So you would consider that a fair number.
Yeah.
And Ms. Rayner, you would consider that a fair number?
Yes.
Judgment for the plaintiff. We're finished. Thank you very much.
Thank you.
This court is adjourned.
I think it was fair. I just wish that my daughter would have been able to dance.
Money was due to me, and she was not paying.
I had to go in and be the one that broke her heart.
She argued with every statement we sent her.
We've already found a new studio, and it's amazing.
Pay your bills.
It's a big blessing in disguise that my daughter's not with Jenny anymore.
I'm sure you were a great dancer back in your day. Maybe ballet now isn't for you, but I'm sure you were the cutest one in the class. But I do think it was unconscionable for the owner of the dance studio to agree that the mother only owed around $900, and she wanted to have this court pay her almost $9,000 in late fees and interest. I mean, I think just unconscionable.
It was a good shot. You know, usually when you do a contract, a formal contract, contracts usually say if any part of this contract is found to be either unconscionable or illegal, the remainder of the contract remains in full force and effect. Usually you have something that says that. Well, this was just an acceptance of the school policy, but the school policy clearly was flexible.
It was, and as soon as she said that, I was hoping that she would have drawn up for those 5 or 6 parents that were on a different payment plan. I would have hoped that she, as a business owner, would have drawn up something mimicking a contract with them to show what their agreement was.
Memorialize that agreement.
Because as you said, well, if you're flexible on this point and that point, why are you not flexible on the interest that you
interest point,
exactly,
which sounded unconscionable.
It did.
Anyway, I really, Sarah, remember those dance classes and crossing Parkside Avenue to go to Miss Nottage's studio. The thing that I remember most about it was the acrobatics class. I swear they had something strung up that looked like a torture chamber. It was strung up from the ceilings and you were put in a harness. You started from one end of the room, and when you got to the minute, she pulled you up on a pulley and you were supposed to do a somersault. And I remember I couldn't get off the ground. My little chubby legs were
flailing,
and I couldn't get my behind over the rest of my body.
Listen, I'm not a dancer either.
And then I started thinking about law school.
Yeah, I think that's a good career path.
Right.
Case 2088, Jenkins versus Barnes. All parties, please step forward.
Fenshia Jenkins is suing her former roommate, Victoria Barnes, for rent and a security deposit.
Miss Jenkins, you were a short-term roommate of the defendants.
Yes, ma'am.
She put an ad on the internet.
Yes, it was in a Facebook group. I was referred by my college. It was for subleasing, rentals, apartments, of that sort.
A room?
Yes.
Do you have a copy of the ad?
I actually do.
I would love to take a look at it.
No problem.
What college do you go to?
University of Alabama at Birmingham.
Miss Barnes, you were pretty specific in this. It says it's average about $800 a month. Utilities included, unfurnished, looking for a female roommate, sublease, personal, bedroom and bathroom, pool, tennis, laundry site. Must be willing to complete a background check.
Yes.
Okay. And did you go to look at the room?
Yes, ma'am.
On what date?
It was the same day that I signed the sublease, which was, I'm so sorry.
It was February the 10th.
No, I moved in on February the 10th. That is incorrect. We signed our sublease on, I believe it was actually maybe January 22nd.
Does it have a date on it?
This only has the date for when I will be moving in and moving out.
May I please see it?
The date is on the signature page.
Okay. It's on the last page of that packet.
You don't have to help her prove her case.
I just want to make sure she got it right.
You don't have to help her prove her
Yes,
case.
ma'am.
Well, who crossed this out? It says subleasee is one of, first it said 1, that's crossed out, and then it said 2 total tenants occupying the premises.
I did cross that out because it is 2 of us. And I accidentally wrote one of 1, but it's 2 of us total. And that was crossed out on the date that I signed it.
Is that correct?
Yes, it was quite a few changes on there.
So it was agreed that there would only be the 2 of you occupying the premises.
Not completely correct.
That's what it says, that there would be 2 people
yes, ma'am,
occupying the premises. Am I correct?
In the initial agreement, I made it clear that...
No clear. This says the subleasee's interest in the sublessee is 1 of 2 total tenants occupying the premises. That's what the lease says, which means there are only 2 people, according to this sublease, which is signed, who will be occupying the premises. That's all it says. I haven't finished the next page yet. But that's what the lease says. Not what you made clear, not what you might have said outside of this. This is what's binding.
Okay.
And this indicates that the subleasee, that's you,
Yes, ma'am.
does not need to obtain her permission
Not at all.
overnight guests, which would make sense that she doesn't need your permission to have overnight guests.
Yes, ma'am.
Okay. This is what your case is about. Now I've read this agreement. You moved in February 10th?
Yes, ma'am.
And started to have difficulty because Miss Barnes has a boyfriend. That would be you.
Yes, ma'am.
And he was there a lot.
No, that was not a problem.
Well, according to you, it was a problem when he had his own key.
Yes.
And he came, according to you, unannounced.
Yes, ma'am. Alone.
Well, it doesn't say that he has to be announced. I can understand it if he was occupying the residence with his own key and there all the time. That certainly would be in violation of the lease. Would you stand up for a second? Tell me your name, sir.
It's Sean White.
Are you and the defendant currently living together now?
No.
Have you ever lived together?
No.
Can you tell me why it would be that you would have a key to her premises?
Well, she is my fiance. We've been together almost...
Because she's your fiance?
Yeah.
When did she become your fiance?
Around a year ago.
And is there any reason why you're not living together?
Yes. In recent...
Yes. You're going to tell me.
Yes, ma'am. I'll tell you. In recent events, I just lost my father, and I'm trying to launch my trucking company and get that off the ground, so it's just... wouldn't be the best thing right now.
How far is your residence from your fiance's?
About an hour and a half.
And her residence from your business?
I'm a truck driver, so I'm always mobile, but where I load at, she's usually close to it.
And that's when you stay at the house?
Yeah.
And how many times a week do you load your truck?
Close to her, maybe 2 or 3 times.
2 or 3 times a week?
Yeah.
So that means that you're spending either 2 or 3 nights a week at her house?
Yes.
Yes. And that's been going on for how long, sir?
Just this year.
So far, we're doing fine. You see, I don't yell unless someone provokes me. He seems like a very nice man, nothing that frightens me, right?
Thank you.
And he visits his mother on Sunday. The guy is a hero, perfect for you.
Thank you.
I don't know what you want from her.
Vanshia Jenkins claims her former roommate, Victoria Barnes, owes for rent and a security deposit.
Mr. White, do you keep a certain amount of clothes at Miss Barnes' apartment?
No, Your Honor, they're usually in my truck.
When you're going to stay over, do you bring up a bag or do you bring up a backpack? What do you bring up with you?
A bag and a backpack.
Do you have toiletries in her bathroom?
No, ma'am.
You carry that with you?
Yes.
Now, when you're on the road, if you stay over 2 or 3 days a week at Miss Barnes's house and you're on the road, how many days a week are you on the road and sleeping either in your truck or at a motel or at a truck stop?
Between 2 and 3 days. It's all depending on where I go.
So that brings us to maybe 5 days a week or 6 days a week. And where is your home?
Aforementioned 1 hour.
Is that where your father lives?
I'm sorry, but he's passed.
Oh, he passed?
Yes.
Okay, so the house that you're staying in is his house?
Yeah.
Anybody else live there?
My mother.
So that 1 day a week you stay with your mom?
It's usually probably a Sunday when I don't have anything to do.
Do you stay at your mother's house?
Yes, that's my primary residence. Like it's maybe two days out of a week.
Mr. White, this is what we're getting. You see where we're starting to smile now? If you see your mother on Sundays and you're on the road half the week and you're at the defendant's house half a week, you can tell me from today until the cows come home that your mother's house is your primary residence. But if you look at it objectively, put your hand down. If you look at it objectively, you're on the road part-time. When you're not on the road, 3 times as many days a week you stay at her house. 1 day you stay at your mother's house, and you tell me that that's been going on since the beginning of the year, which would be January or so of 2022. That's what you just told me, and that actually makes sense.
I beg to differ, though. Like, the time that I stay there, it might be 8 hours, and then I'm back on the road.
I don't care.
And it's like maybe 2 days out of the week.
Now you can sit down, Mr. White.
Wait.
Okay, I get the scenario, and not unusual. You were unhappy with this more frequent access than you were advised of.
May I add, I was not unhappy with how much he was there. It was only the fact that he had came in by himself, and she hadn't let me know. I only had told her that that made me uncomfortable, and I got kicked out for it.
That's not true, Your Honor.
Well, when you say got kicked out, I think you acknowledged that you gave her a 30-day notice to leave.
Yes, ma'am, I did.
And other than this issue of house guests, were there any other issues that you had with her?
When the situation happened, she texted me and asked me where I was. I told her when I got home that we can have a conversation, and that's when an argument ensued, and multiple arguments happened after that.
Were they all about house guests?
Just about, yes, ma'am.
And at the beginning, they were all about Mr. White.
Right.
Okay. And your sublease agreement actually specifically says that only 2 people are living there.
Yes, ma'am.
And Mr. White has already made it crystal clear to me that he spends his time either on the road or at your house visiting his mom on Sunday. And that sort of makes this fuzzy. Okay, anyway, it didn't work out. He seems like a very nice man, nothing that frightens me.
Thank you.
Right?
Thank you.
And he visits his mother on Sunday. The guy is a hero. Perfect for you.
Thank you.
So you moved out, you got another apartment, whatever it is. I don't know what you want from her.
I want the money that I gave her, period. And
What money?
So she made me pay her security deposit.
No, just a second.
Yes, ma'am.
Security deposit.
Yes.
Fine. Did you get your security
No, ma'am.
deposit back?
Absolutely not.
How much was your security deposit?
$350.
Okay. Did you return her security deposit?
No, ma'am.
Okay. You have to return her security deposit.
Well, being as though she left the room damaged, I didn't feel like I needed to.
You have photographs of the damage?
I have stained carpets.
Just a second. Do you have photographs of the damage?
No, ma'am.
Good. $350. She gets her security deposit back.
Yes, ma'am.
What's next?
The remainder of the rent for the month that I moved out, which I moved out within.
Just a second.
Yes.
Did you pay her March's rent?
Yes, ma'am.
You did?
Yes, ma'am.
Okay. You paid that the beginning of the month?
Yes, ma'am.
Okay. And how much did you pay her?
$630.
Incorrect.
Clearly paid you February's rent when she moved in.
Yes, ma'am.
Did she pay you March's rent?
So she gave me...
That's either a yes or a no. If she paid you March's rent, did you get 2 months' rent from the plaintiff?
Yes, I did.
Okay. And she moved out.
Can I explain why I don't feel like I'm entitled to give her the money back? Because the apartment complex, when we got into the initial argument and I was made aware of the slander and the allegations that she was portraying against Sean and myself, I was told that being as though I made it legal on paper that she has 30 days to the resident, that she would still access to my apartment for the remainder of the month of March until the 17th of April. And also Sean has seen her sending people to my house, her coming in and out of my house when I was at work, supposedly gathering her things, but my personal belongings came up missing.
Oh,
and she had access
Hold on
to
one
it.
second. After March 17th, did you have any property in the apartment? Just be very careful what you say to me. After March 17th, you say you physically left the apartment. Did you have any property there? That's either a yes or a no.
May I confirm the date so I just don't give you false information? Okay, thank
Yes.
you. So the very last day that I was there was...
March 22nd.
Shh. You keep doing that. You keep doing that.
I'm sorry.
Okay, good.
Okay, so the very last day that I was there was on, I believe, March 20th.
Oh, then you owe for the month of March. Then you get your security deposit back, $350. We're finished. Thank you very much.
That's all, Judge.
What? That's what she gets, her security deposit back. That's it. She gets her security back. Doesn't get rent, doesn't get moving costs, doesn't get damages. She gets her security deposit back. Goodbye. Have a happy life. Have a nice day.
This court is adjourned.
I really thought that everything was fairly normal until just the conversation about me.
A security deposit is the least of my concerns because I don't owe her rent.
Expressing my discomfort with her boyfriend being in the house alone with me.
For her to even mention him harming her in any type of way is not only offensive, but it's disrespectful.
It wasn't like, he was my personal friend or I met him anywhere else. I met him through her, so I just didn't want to be home alone with him.
Honestly, it's outrageous. The implicate that I do anything to her is it's beyond me.
My safety does come first. I put me first. I gotta put me first.
I wish her nothing but the best away from me.
I thought that the fiancé was absolutely charming.
I did too.
I thought he was such a nice guy.
Visits his mom on Sundays, has a job.
Hard-working, regular, stayed home while his dad was ill. Really a nice guy. But it was clear that he may say my primary residence is with his mother, but that's a visit on Sunday. When he can, he stays with his fiancée in the house. Clearly that was not part of the lease. But forget about that, Sarah. She's a tough broad.
Oh, a little bit of an attitude.
She had a little bit of an attitude. So I don't know.
It's always the nice guys that end up with
somebody with
women with the attitude.
He's got to watch his P's and Q's.
Oh, yeah.
Anyway, I'm glad they're happy, and I'm glad that they're together in their apartment, which is probably the way she would prefer it.
Kaloyan Popyanchev is suing fellow motorist Spencer Gilbert for car damage.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case number 2084, Popyanchev versus Gilbert.
Thank you.
You're welcome.
Mr. Popyanchev, you were driving in your car, 2008 BMW.
That's correct.
And that was on the 14th of November of last year. Tell me what time of the day this accident happened.
It was approximately 3:15 p.m.
So daylight hours?
Yes.
And tell me where you were going.
I was going eastbound on Sunset Boulevard in Beverly Hills. I was driving...
Eastbound on?
Sunset Boulevard in Beverly Hills. I was driving in the right, so-called slow lane, when I tried to make a right turn.
Where?
It's an intersection. The name of the street is Palm Drive.
Is that intersection controlled by a light or stop sign?
No, there is no stop sign or a light.
At that intersection?
That is correct.
I assume somebody has a video or a photograph of that section that would demonstrate that there is no light. You do. Is there a light or a stop sign at that intersection?
No, Your Honor, there's not.
Did you put on your signal indicating a right turn?
Yes, I did.
How far from the corner?
I can't state distance, but it was approximately 5 seconds before I reached the intersection.
Was there traffic that day?
Yes.
A lot?
Very light. It was Sunday.
So far, Mr. Gilbert, is that correct, that there was light traffic on that day?
Yes, Your Honor.
And you were traveling on a motor something called a Vespa, which is a small...
Small scooter, yes, Your Honor.
But motorized.
Yes, ma'am.
And I don't know about these things, does a Vespa have to be registered and have a license plate on it?
I do have a license plate on the Reddit.
Okay, so your Vespa is registered as a motor vehicle, and you have a license plate.
Yes, Your Honor.
Now tell me what happened, sir.
As I proceeded to make a right turn onto Palm Drive, I just heard an airflow. It was a big bang. It was an impact.
On your passenger side?
Yes, on my right passenger side. And I realized that there was a small motorcycle or a moped that hit my vehicle.
Hit your side. And you were the person riding that Vespa?
Yes, Your Honor.
Okay. May I see the damage to your car?
Yes.
Sarah Rose, get me the price of the 2008 BMW 7 Series.
Will do.
Thanks. What you're talking about is this damage, sir. Is that correct?
Yes, front passenger.
I see.
Yeah.
I've just made a circle. Can you see the circle that I've made?
Yes, that is correct.
Okay. And that is, Mr. Gilbert, where you hit him with your Vespa.
It's where he hit me with his car.
No, he can't hit you sideways, sir.
He sideswiped me.
He can't hit you sideways, sir. He can't slide into you. Now, whose ever fault this was, I'll try to figure it out. But you hit him because this is the area of impact. Cars don't go sideways, they go front. You have pictures of your Vespa?
Yes.
I'd like to take a look at them.
Your Honor, based on a 100,000-mile BMW 7 Series, between $4,700 and $7,800 is about the range.
I just want to know, because I have to see what this kind of damage. He's suing for $10,000, which is ridiculous. That doesn't show me much, actually. Okay, so I can't see the front of your Vespa, sir. I assume that the front is the end that's damaged because I see the back.
Yeah, the front end was completely collapsed.
So the front
impact
of your Vespa was damaged because that's where you hit him with your Vespa.
No, you're
The
not.
back
That's
end
incorrect.
was not damaged, nor does it look like the sides are damaged. These are the pictures you gave me. The only thing I can't see is the front crushed end. Am I correct that I can't see the front crushed end? Okay.
Yes.
So now I'm telling you that based upon these photographs, yours and his, you hit his car. Okay, now that's the chart. Whose chart is that?
It's from the police report.
Great. Now, the police report doesn't show a bike lane there or any other lane. It shows that there's a car traveling in a car lane and the Vespa hitting. See, he can't hit. You can hit. He can't hit you. Now, tell me, sir, why is it that you were driving where you were? You were behind him initially.
No, Your Honor. I was traveling eastbound down Sunset, heading to work. He was right next to me. When we got to Palm, he turned into me, pushed me. I barely was able to keep control of my vehicle.
Is what you're telling me that your Vespa was never behind his? This you're not getting. I want you to get this right out of your mind. Your whole car isn't worth $10,000. Let's be serious. I don't have all day. Do you have a bill?
And later today.
And I know you're dying to tell me that there was noise there, that you couldn't live there, that it was terrible. Well, that's what happens when you live in a place with a whole bunch of other people.
Kaloyan Papionchev claims fellow motorist Spencer Gilbert owes for car damage after hitting him with his Vespa.
Is what you're telling me that your Vespa was never behind his?
No, I was never behind his vehicle.
Do we have any other video?
I do have a dash camera video of the...
May I see it, please? Play it again, please. Start from the beginning. So let's go slowly. Okay. Well, it's clear to me, Mr. Gilbert, that you came up behind him. Just go back a little bit. You weren't right next to him because...
I was next to him because as he slows down to make his turn, that's when he makes contact with me. I was right next to him the entire time.
Impossible. May I see the police report, please?
Yes. There's actually 2 police reports.
May I see them? Was anybody given a summons on that day? Nobody. Neither party was given a summons. Is that correct?
Not that I know of, Your Honor.
Okay, so this is the narrative after witnesses were questioned, and the opinion based upon the witnesses' testimony and yours, and the fact that the police officer actually heard in the video the clicking of the turn signal indicating a right turn approximately 5 seconds before the right turn was executed according to the police officer as a result of viewing the cam that he had, the video, that he was making a slow right turn. He had turned on his signal approximately 5 seconds before, and you were coming up on him on your right. And it says, based upon the video footage, I determined that the first car, and that would be his, should not have been placed at fault for this collision because he activated his turn signal and made a safe turn to go southbound on Park Drive. The fault of the collision is on the part of Mr. Gilbert for violating 21-755 CVC, which states in part that the driver of a vehicle may overtake and pass another vehicle on the right only under conditions permitting that movement safely. I'm reading you the police report. Do you have another police report?
Yes, I do, Your Honor.
Prior to this or after this one?
This is the only police report that I know of.
Oh.
I wasn't aware there was 2.
Well, this was a supplementary police report. What is the date of yours?
All I have is what my lawyers gave me.
Oh, well, I'm going to show you this one, sir.
Yes, ma'am.
And this one was after viewing the cam.
Yes, Your Honor, my police report predates his.
Predates it. Well, that's after the officers looked at the dash cam, heard the signal, and saw you coming up from behind. I'll take it back now. I've seen the damage on your car, sir.
Yes.
Which, while I wouldn't like to have it on my car that's 14 years old, it is on your car. It's not worth $10,000. Your whole car isn't worth $10,000, sir. So if you want to show me a reasonable estimate for fixing that, I'll be more than happy to look at it.
Yes, I do. And this estimate was given to me by the only body shop that is authorized by BMW.
I'll find another body shop for a 14-year-old car. I'm certainly not going to consider giving you anything near the value of your total car for something that is on the door of one side of the car. Have you had the car fixed, sir?
I had the entire door replaced, but it's still...
Replaced by whom?
By a body shop.
Good.
Yeah.
And if you had the whole door replaced, you must have a bill. This you're not getting. I want you to get this right out of your mind. Your whole car isn't worth $10,000. Let's be serious. I don't have all day. Do you have a bill for the door that you replaced from a body shop, which is what I said a moment ago?
No, I do not have it with me. The vehicle is still due paint and dents and scratches repair.
Well, they're going to fix the car, and if they can fix the car for $2,000, have it fixed. That's my judgment. Judgment for the plaintiff. We're finished.
This court is adjourned.
Certainly not happy about it.
I am happy. It is something.
The problems that this gentleman's caused my life.
It happened in about 2 seconds.
I was like riding right next to the dude and he just turned into me and I went into the wall and that was pretty much it.
I had to call 911 immediately because I wasn't sure if he's dead.
Because of what he did, I wasn't able to go to work for 2 weeks. I lost 2 of my jobs.
First thing to do is you call 911 and then deal with, the rest of the circumstances.
One theme that we see far too often is plaintiffs coming here or to any court asking for a large sum of money, in this case $10,000 for a car that wasn't even worth $6,000. And instead of showing us an estimate of fairy tale land of what was going to fix it, show me a receipt for what you paid to fix the damage.
Yeah, he did fix the damage.
He fixed the damage already, replaced the whole door. You don't have a receipt for that. You don't have a bill. You don't have a nothing, which leads me to believe that it was a lot less expensive than $10,000. So I thought your judgment was generous, given that he had no proof. I would have said goodbye.
Well, he did damage the car. Not that I'm going into history, but as one who has, on occasion, hit a stationary object, even allegedly hit a stationary object, and get a little nick on a bumper on a car. It's expensive to fix a car. So he had a car that looked in perfect condition. It wasn't after it was hit. He's entitled to have it look like what it looked like before.
I just felt there was sort of a bait and switch with the $10,000 estimate, but I already got it replaced.
Fixed. I think that he said that. I think that he said that unintentionally.
I also think he did.
It's okay.
Won't get one over on us.
No.
Case 2090, Oquendo versus Villarreal. All parties, please step forward.
Amber Oquendo is suing her former tenant, Nancy Villarreal, for unpaid rent.
Miss Oquendo, you own a home.
Yes.
How large is the home?
It's 4-bedroom, 2-bath, and approximately 1,700 square feet.
When did you purchase the home?
2018.
Can I ask you what the cost was?
$225,000.
And you live there in the house, just you, with whom?
I don't live in that house. That's my rental.
You bought it as a rental? Somebody was playing their music loud. It was a problem for you.
Yes.
You asked them to be quiet.
Yes,
you told her it was a problem.
Yes.
And then there was some sort of a kerfuffle. I don't know what happened. You want to tell me?
Amber Oquendo claims her former tenant, Nancy Villarreal, owes for unpaid rent. Nancy is countersuing for her security deposit.
Now, you bought it as a rental? You bought it as a business?
Originally, I purchased it and I lived in one room. My kids shared a room and I rented 2 rooms until I was able to establish basically a history of being a landlord. And I then purchased another home and I live in my own residence, and that one is fully a rental as of now.
And also a resident of that home are your parents?
Yes, they are in the master.
And you have another tenant there?
Yes, there are a few other tenants.
Tell me who.
So I have one tenant who has asked not to be identified by name, but he is in one room that I have marked as room number 2. And then I have another tenant who's in room number 3. And then Nancy was in room 4, and there's now a new tenant in that room.
Okay, this is what it's about. The defendant was a tenant of yours. It didn't work out. And it was a short tenancy. I think it lasted no more than a month.
Yeah, right.
Is that right? June of this year?
Yes, Your Honor.
It didn't work out. She left. It is your claim that she left owing you a month's rent. And I assume from your paperwork that the month's rent was $774.
So it was $650, and then the $774, the remaining difference was just for being served and then court costs. But month rent was $650.
$650. And when the defendant moved in the beginning of June, did she sign a lease?
Yes, and I'm just going to correct you. Sorry, she moved in May 7th, so just wanted to correct that. But yes, she did sign a lease.
May I see it, please?
Yes, ma'am.
Thank you.
Yeah.
You have a copy of your lease, Ms. Villarreal?
Yes, I do.
Okay, good. So it's a month-to-month tenancy. It's an at-will with 30 days written notice. Okay. According to the lease, there was a security deposit of $650.
Yes, ma'am.
Did the defendant pay that when she moved in?
Yes, she did.
Okay, because that's your counterclaim. You say you want your security deposit back.
Yes, ma'am.
I assume from reading both of your complaint and answer that this turned out to be not a happy tenancy. You don't live there on a full-time basis. The defendant did live there for a short period of time. You moved in, rented a room, and you gave her $650, and you moved in on May 7th.
Yes, Your Honor.
Correct. And you moved out on what date?
I moved out on July the 10th.
So you were there for 2 months?
No, I was there for 1 month.
May to June, June, July. May 7th.
I moved in I believe it was June because I moved out July the 7th.
Our lease was signed on May 7th, so I know that.
Yes, the term of the lease is beginning May 7th. That's the term of the lease, according to this. So I don't care when you moved in.
Okay.
The term of the lease was May 7th on a month-to-month basis. So you were there from May 7th to July 10th. So you were there for 2 months.
Okay.
We're going to get into the whys, wherefores in a moment, but did you pay the month of May?
Yes, Your Honor.
Did you pay the month of
Yes,
May?
ma'am.
Good. Did you pay the month of June?
No, Your Honor.
Okay. And you lived there until July 7th?
No, I actually lived there until...
You just told me July 10th, as a matter of fact. Whitney's going to tell me what date you gave as your move-out date. You said it was July 10th.
She said, I moved out on July the 10th.
Okay, July, and it was, yes. July
so you
10th.
were there for 2 months?
Yes, Your Honor.
Okay, if you were there for 2 months and you only paid 1 month's rent.
Yes.
So far, you owe her 1 month's rent. Did you return her security deposit?
Yes.
Did you receive your security deposit?
Yes, Your Honor.
How much?
$650.
Okay, so you have no counterclaim. The counterclaim is for your security deposit. The rest of it is nonsense. You moved out, you wanted to pay your moving costs, your hotel fees, and everything else. That's ridiculous. Okay. So if you've received your security deposit now, what you owe her is a month's rent, which is $650. And I know you're dying to tell me that there was noise there, that you couldn't live there, that it was terrible. Well, that's what happens when you live in a place with a whole bunch of other people. Did you look at this room before you moved in?
Yes, I did, Your Honor.
Okay, so you went to the house. Mm-hmm. When you went to see the house, Amber was there. Mm-hmm. She introduced herself as the landlord. That's what it says here.
Yes.
And she let you know that she wasn't in the house, that her parents were in the house as tenants, but she wasn't in the house.
Yes.
And you moved in and somebody was making noise. Somebody was playing their music loud. Mm-hmm. It was a problem for you.
Yes.
You asked them to be quiet.
Yes,
you
Your
told her it was a problem.
Yes.
And then there was some sort of a kerfuffle. I don't know what happened. You want to tell me?
Yes, Your Honor. I am a federal employee, Your Honor. And when I signed this lease back in May, it states there, and I'm also in recovery, Your Honor, and it states very clearly in the lease that there is absolutely no smoking on the premises or no drugs on the premises, Your Honor. There was absolutely marijuana being smoked in the house. And right after I brought that to her attention, I then received a 30-day termination notice.
Okay.
Because I absolutely could not live in that house anymore with my job. I felt it was not a safe place for me.
Where did you go? Just a second. Is that your son?
This is my son.
Okay. Does he live in the area? I know you called him and he came and helped you move.
Yes.
Correct?
Ma'am.
Who does he live with?
My son? He rents a room with roommates.
So he has roommates?
Yes.
Tell me where you went when you left. You didn't get a 3-day notice to quit. You got a 30-day notice from her that she was not renewing the lease pursuant to this.
Right.
You chose to leave in 3 days. That was your choice.
Because
you had 30 days to stay, and you had a month-to-month tenancy. Mm-hmm. Okay? You chose to leave. So where did you go?
I got a U-Haul. I didn't really have a place at the time to go, but my boy's grandmother offered her place to me. So I stayed there for a couple weeks. She said, you pay $180. I'll let you stay here for a couple weeks until I was able to find another place, Your Honor.
And then you did?
Yes, ma'am, I did.
Great. Okay. So the security deposit you have, and she doesn't have her month's rent, which is $650. Are we done here? Judgment for the plaintiff in the amount of $650. We're finished. Thank you.
This court is adjourned.
I am not aware of anyone using marijuana in my house.
There was marijuana being smoked in the house.
My dad says that he's not smelling it, so I guess I can't really attest to the legitimacy of that.
It was not a safe place for me to be.
You know, some people don't realize, Sarah, that if you leave a premises that you have lived in, it's like going to a restaurant and ordering a steak and then delivering the steak, you're taking a bite and say, you know, I really don't like that steak, and finishing it, and then telling the waiter you're not going to pay for the steak. I always say you ate the steak. If you're a tenant and you find the living conditions such that, you know, you find it untenable to live there, you have a prerogative of changing your residence, but you don't live there for 2 months and only pay for one, and then make excuses because you ate